2016. Time flies, and we would like to recognize our three new members of the commission, and they are Commissioner Christopher Lee, Carl Kramer, and Commissioner Debbie Melton. And I'm sure there will be some questions you'll have, if not questions of parliamentary procedures, which you're welcome to address. Ms. Shaw, would you like to call roll?
Chairman Roberts.
Here.
Commissioner Lee.
Here.
Commissioner Galvin.
Here.
Commissioner Clayton.
Here.
Commissioner Fox.
Here.
Commissioner Kramer.
Here.
Commissioner Jackson.
Here.
Commissioner Melton.
Here.
Commissioner Murray.
Here.
Commissioner Trickett.
Here. And are there any more iPads? A spare?
Else?
Thank you. Sorry.
Want to let out here first.
Commissioner Norton.
Here.
Commissioner Parr.
Here.
Commissioner Vaughn. Here. Commissioner Tomaso.
Here.
Commissioner Levy. Commissioner White. Commissioner Evans.
Here.
We have a full house.
Full house.
This is the first time I've ever seen this happen.
I could have taken the day off.
We definitely have a quorum today.
And contrary to prior instructions for microphones, get away, sit back from them instead of closer.
Yeah.
That's kind of tricky. Would you read into the record the notice of the meeting, Ms. Shaw?
This meeting's date, time, and location have been noticed on the Tennessee Motor Vehicle Commission website, included as part of this year's meeting calendar since July 13, 2015. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission website since October 18, 2016. This meeting has also been noticed on the tn.gov website.
The agenda for today's meeting. Mr. Reddish, do you want to add separately the case number 14 from the legal report?
We'll cover that when we get to the legal report. On the agenda, I believe Car Express LLC, we're not going to cover that under dealer appeals.
Recommended changes? Hearing none, by voice vote, all those who approve of the agenda, say aye. Aye. All opposed, say no. If you'll look at the minutes, if you haven't already, from July 25th, 2016, any exceptions, and of course we'd ask the new commissioners not motion to accept the minutes by Commissioner Fox.
Commissioner Jackson, second.
Seconded by Commissioner Jackson. Any discussion of the minutes, or the motion to approve the minutes for July 25th, 2016? Hearing none, we call for a voice vote. All those in favor of the motion to approve the minutes from July 25th, 2016, say aye.
Aye.
All opposed, say no. Commissioners, we will have request for a change of a decision by the legal staff for denial of a license. And there are certain routine you might be aware of.
IT's on its way down, that's all I wanted to add at this point.
Okay.
They are on their way down.
No, the 5-year time for license, before license can be approved. Could we read that to the new commissioners so that, because we don't.
Want to read the actual statute?
Yeah, that'd be fine.
Does anybody have one down here?
Statute that would say that denial is more or less automatic until 5 years after the. You're going to hear a lot of that, most likely. So.
The statute referring to Chairman 5517-114A1C. The licensee or applicant has been convicted of a crime of moral turpitude and fewer than 5 years have passed since the license or applicant has completed serving the licensee's or applicant's sentence, including parole or probation, whichever is later. And the start of that, I should have started this. The commission may deny any application for a license or revoke or suspend any license after it has been issued upon finding that. So basically we read this as if a salesperson has a crime that legal considers to be a crime of moral turpitude, the commission has a discretion to deny that salesperson's application. If it's within 5 years of the end of any kind of probation or prison sentence, we take basically the last day that the court ordered that individual to serve, whether it's incarcerated or probation or supervision, add 5 years onto that date. And then if they're beyond that, we don't have the discretion to deny them, but if they're within that 5-year window, then we do. Right. I mean, either if it's past 5 years, you don't have discretion really either. You don't have discretion to deny them, and you can't approve them.
Less than 5 years, you can't routinely approve them. It has to come.
You can if you like to.
We can, the staff can.
If you've previously told the staff not to, then I wouldn't advise them to do it.
I might not have said that. In the less than 5 years after the term has been served, must deny the application, and then appeal can be made by the applicant.
Yes, that's the procedure.
Now that I've muddied that up for everyone, where is our? We'll ask the first applicant, Kimberly Metters, to come forward, please. And don't be concerned, Ms. Metters, we'll get it right. We've done this many times. Metters, would you read to the commission the reason for the denial?
Review of Ms. Metter's salesperson application and judgments does reveal a conviction for a crime involving moral turpitude. In the case of Ms. Metters, the documented conviction is for possession of cocaine with intent to sell on October 21st, 2013. Ms. Metters received a sentence of 6 years supervised probation. Therefore, application may be denied until September of 2024.
Would you address the commission as to why the
Sir, I've applied for an application for a license just to be a productive member of society. I've got a treatment letter from Judge Moreland. I participated in his program for the last year and have 6 months more of supervised treatment. Fraudulent or violent crimes, and I just want to be a productive member of society.
questions? Before we go into questions, would Commissioner Levy, would you see if you could pull? I think the next one would probably be the one to begin with. questions?
Commissioner Vaughn, I have some
Commissioner Vaughn.
questions. Was this the first time that you were in trouble?
No, ma'am, I've struggled with addiction for quite a while, and I'm trying to address all those areas.
Have you had any trouble with the law since this arrest? Okay.
So, why are you wanting to be a salesperson? Are you connected to?
Yes, sir. My husband, his brother owns the dealership, and they allowed me to be employed there last December. I do some paperwork and work with auctions and stuff. No, ma'am, no.
Jackson, somewhere, yeah.
I was looking to see,
I'm not sure I got it right. But
now
can you
cool
move
it
2
off
more
a little
inches?
bit.
Okay.
I was looking to see, what was the amount, can anyone, on the cocaine? How much was it?
Cocaine for personal use, or were you
Yes, sir.
selling it? Were you
No,
were
it was personal use. I had a prior record to that. It wasn't a resale charge or anything like that. They do it as intent when you've had a prior record.
It appears it was less than half a gram.
Yes, sir.
One more question. How did you get caught? I mean, were you out somewhere doing it? Can you
I
explain
was
it?
pulled over as a traffic stop.
Possession?
Sir.
Matters, would you like to introduce the gentleman that you brought with you? And
Tim
what his?
Tenen, he's the owner of 24/7 Auto Sales.
Okay. Your name again, sir?
William Tennant.
Mr. Tennant, would you like to speak to
Yes,
Commission regarding,
She's been employed for me ever since December, and she's a hard worker. Shows up every morning on time, works over, you know, she's real dedicated to my business.
like she would be a good risk company in terms of, and
Girl, she stayed clean, she don't drink or nothing, she's straight. She's been
Turn-
straight ever since the deal, since she got arrested.
questions? Commissioner Norton?
I have a question. You mentioned your treatment and how you struggled. And you said something about you're gonna be finishing some kind of treatment. But my question to you is, going forward to be successful dealing with the consumers, are you gonna be maintaining some kind of program? I mean, I'm familiar with, these situations. I mean, it's almost like you can't go along by yourself. You have to be committed to some kind of program. Are you committed to a program to stay clean?
Yes, sir, I am. I also have verification books where I attend daily meetings, 7 days a week. I'm monitored by Avertest. They do monitoring testing during the month, drug screens. I have aftercare with Davidson County Davidson County Drug Court, Judge Casey Moreland. And it's just something I really want to do.
I have one question. How long do you plan on staying in a program?
Well, I plan on staying in the program continuously because it is a lifelong journey. I won't be monitored, but it'll be a self-program, and I'm committed to that, and I have verification. Right.
Dealership owner, do you have any type of program that you're gonna be doing a follow with her after she completes the program that she's already in? Do you have anything in place there?
Not really, but I will say that she stays in her meetings. You know, I let her off whenever sometimes she'll go to a lunch meeting or whatever. She's been attending meetings every day. She's real dedicated to it. She's got grandkids she's taking care of, and she's helping raise a couple of her grandkids. She's doing real good. I think she does need a break. The girl's a real hard worker, and she's dedicated. She's dedicated to her grandkids and to my business. So,
One more question to the petitioner. How long the program that you have to go and have yourself checked on a monthly basis? How long is that program gonna last?
It's an 18-month program. I began in December. Uh-huh.
Commissioner Galvin here. Where did you work prior to,
I worked for
Auto
the state
sales.
of Tennessee for 7 years for the Department of Environment and Conservation with the felony on my record.
and something you just decided you wanted just to be a salesperson?
Well, my husband, I've been working, they allow me to come to work there. It's hard to get employment with record. He allowed me a chance to prove myself and to come to work for him, doing the clerical work at the office and with the auctions. And it's just something I want to continue to further my career in his family business. I mean,
Sir, how many
Asking for a
salespeople do you
chance.
have right now?
So I think I have like 4. I'm not really for sure. How many sales?
there's 4. There's Glenda Tennant, Samuel Tennant, which is his mother, his brother, Bradley Breeden, and I think that's all that's there now. Brian Brown passed away in October.
And I had a nephew too that signed up as a salesperson. He helps me some on weekends. He's still in college,
Johnny Cox.
Johnny Cox.
Basically, it's a family-owned business.
Family-run business.
And is there any ties between you
I was married to his brother in July,
married to his
and I
brother?
brought my marriage certificate with me. My name, when I applied, my name was Metters, and it's now Tennant.
Further questions?
Second.
Not sure we got that on the record, Commissioner Jackson. That's, I instructed to move them back, and now we,
Commissioner Jackson, motion to grant the license.
Second. Commissioner Vaughn.
a motion to grant by Commissioner Jackson, seconded by Commissioner Schaefer. Any, Schaefer Vaughn, any discussion of the motion? Hearing no discussion, Chair calls for a roll call vote on the motion.
Roberts,
Yes?
Commissioner Lee. Yes. Commissioner Galvin,
Yes.
Commissioner Clayton. Yes. Commissioner Fox.
Yes.
Commissioner Kramer. Yes. Commissioner Jackson,
Yes.
Commissioner Melton,
Yes.
Commissioner Murray,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
Yes.
Commissioner Parr,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Tomaso,
Yes.
Commissioner Levy,
Yes.
Commissioner White, Commissioner Evans. Motion carries.
Thank you all so much.
Congratulations. Good luck.
Thank you.
Michael Love, Scenic City Motors, LLC. Love, and Mr. Reddish, if you would state why the license application was denied.
Review Mr. Love's salesperson's application and judgment does reveal a conviction for a crime involving moral turpitude. In the case of Mr. Love, the documented conviction is for conspiracy to distribute and possession with intent to distribute heroin. Applicant's sentence was terminated on June 29th, 2016. Therefore, application may be denied until June 29th of 2021.
Love, would you like to address the commission as to why you feel like you'd be a good decision for you to have a dealer, salesperson license?
Well, I think I've completely turned my life around from, before the conviction. I was a heavy user in drugs. Found a lot of other outlets as to not use. Program some as far as the AA goes, but just hobbies and charity events that I take place in. All that stuff's helped me stay clean and just, really strive to be a good person in society. So.
Does the commission have questions for Mr. Love?
Commissioner Vaughn, was this your first arrest? Have you been in trouble with the law since?
Oh, not at all, no.
Okay.
What other outlets have you found to get you away from the addiction?
I go and volunteer quite a bit with a program for youth, just to get them away from bad influences. We help out teaching ballroom dance to underprivileged children. So
Do you have some supervision in that program?
I actually work at a place, or used to. It's something kind of ongoing now, but I used to work at a studio in Chattanooga, so it's part of that.
Commissioner Norton.
You ever sold heroin?
A little bit, yes.
Of your sentence was commenced on 12. What have you done since then for employment?
At first, I worked at Steak and Shake and IHOP, and then I was given a chance as a dance instructor, which has been awesome. And then actually, Daniel has been my boss at his place of work for, or I worked for him for a little over a year. It's a Buckle, a clothing store. So I was doing all three of those things, and at one point I was going to school for heating and air, but decided that wasn't for me.
The gentleman you brought with you like to address the commission? Who are you, sir?
Yes. One of the reasons that I want to bring Mike onto my team is he's been a part of my team at the Buckle. I'm an area manager. I've been with the company for 13 years. Decided to do my own thing and open up this car dealership. And I know just working with Mike, he's won numerous performance awards. It's a performance-based company, never late, never had a problem with anyone. I actually knew Mike probably 8 years ago before he got in trouble. I could tell that he was a good person. I could tell he was on the wrong path. And then whenever he got out, there's another young lady named Autumn who worked for me. Her mom works for the high school that Michael went to. And I was just, I saw Michael come out. I was talking to him, asking him some questions. And part of our job is recruiting. It's a huge part of what we do. It's hard to find good people that you can trust and build a relationship with, that you want to work with. And so I reached out to Michael. He didn't reach out to me. I actually talked to him, saw him. About a week later, I called him, asked him if he would, be interested in a position with me, because I saw him. He was doing good. And I think everybody, if they're a good person, I know people make mistakes. I've got 5 kids. I'm quite a bit older than Michael. And I just wouldn't surround myself with somebody that I don't trust. Like my kids will be, I bring my kids around a lot. We actually, he does a lot of floating, kayaking, pretty good at that. He likes outdoor stuff, and he's got me kind of pretty involved with kayaking. There's some rivers right around Chattanooga that we get a chance to do that kind of stuff. So.
Questions for this gentleman?
I'd like to make a motion that we approve the salesman's license.
Second.
Motion to approve by Commissioner Vaughn, seconded by Commissioner Trickett. Any discussion of the motion? Hearing no discussion, chair calls for roll call vote on the motion.
Chairman Roberts,
Yes.
Commissioner Lee,
Yes.
Commissioner Galvin,
Yes.
Commissioner Clayton,
Yes.
Commissioner Fox,
Yes.
Commissioner Kramer, Commissioner Jackson,
Yes.
Commissioner Melton,
Yes.
Commissioner Murray,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
Yes.
Commissioner Parr,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Tomaso,
Yes.
Commissioner Levy,
Yes.
Commissioner White, Commissioner Evans.
Yes.
Motion carries.
Congratulations, Mr. Love. Thank you. Aaron White, Parkside Kia. White, Mr. Reddish, if we could hear for the reason for denial.
Review of Mr. White's salesperson's application and judgment does reveal conviction for a crime involving moral turpitude. In the case of Mr. White, the documented conviction is for possession of cocaine with intent to sell in a school zone on April 19th, 2016. Applicant received a sentence of 10 years supervised probation. Therefore, he may be denied until April of 2031.
White, were you selling to school children?
No, sir. What it was in the Knoxville area, the place where I was pretty much caught at was at a bar called Twin Peaks, and it was actually 998 feet away from Bearton, so I call it Bearton Elementary School. It was during Memorial Day weekend at like 11 o'clock at night. So I have children of my own, so I would never sell to any children. The school zone is what looks the worst on it, and unfortunately, like I said, it was 998 feet away from the school. The act I did was not good, of course, but that's the reason why it was a school zone.
Oh, Twin Peaks is in the school zone.
Yes, sir. It has to be within 1,000 feet of a school, and it was in a like bar area, night area where the conviction happened. So do you understand? It was 1,000. It was 1,000 feet, but it was literally like 998 feet.
Slightly surprised that a bar would be in a school zone.
Right. It's how Knoxville's built.
Any questions for Mr. White?
What were you selling?
It was cocaine, sir. It was, in my ad, I'm 30 years old. It was being young, being around the wrong people in my neighborhood. That's just being dumb, not using my full potential. I graduated high school, attended college, played sports, just made some wrong decisions in my life. Ever since actually that happened in 2015, actually it was in 2014 is when it happened. When I was released in 2015, I was just redeemed. Like I just had a big redemption in my life to where as soon as I got out, I did the halfway house for 3 months, completed it, did everything right with it, got out and worked at the Hilton in Oak Ridge, Tennessee. Worked my way up to be banquet leader because I like working with people. With that, I had a chance to work with U.S. Cellular in Knoxville, Tennessee. Those first 3 to 4 months before I got with Parkside Kia, I was salesman of the month every month. I got 15 sales or more. I like working with people. I think that's why they gave me that chance. I've done good with sales. So if you were to ask, why do I want to be in car sales? I mean, I love it. I love working with people. I just love the whole business around it. I know it's long hours, but I know I can provide for my family with this. I have a beautiful fiance, and I just feel ever since I've been out, I have letters from my probation and my lawyer, and even the judge has even told me, I'm just so prized of what you've done since you've been out. And I'm very believe in my faith, and I go to church a lot. I'm involved with the Knoxville Step Up Committee in Knoxville, Tennessee, where we go to different neighborhoods, and pretty much people who have just gotten out of prison, I tell them my story and let them know, you can still do this. I've gotten a lot of no's to get to a yes, and I've told them, hey, I didn't give up. I was young, I did a lot of dumb stuff, and prayerfully, I'm glad that Parkside Kia has allowed me, give me a chance to elevate my full potential.
The sale of illegal drugs, I think, could be lucrative. What were you doing with all that money? Were you supporting other bad habits or a bad habit?
I was actually, when I was using, like as far as partying wise, and I used more than I sold, but it was more of a thing of just to party and have fun. I didn't really have a real bad addiction with it, but I still did the programs and understood what the consequences is of even being around it, first of all. So I do respect the programs that I was in for that.
Mr. Levy had a question.
Staff, based on the memorandum, indicates that the conviction was for possession on April 19, 2016. I presume that's in...
That was
That's the date that if you look at the second to last page in the packet on the bottom right, it says date of entry of judgment. Says April 19th, 2016. It does say arrest date, May 25th, 2014. So there's about 2 years between the arrest date and the entry of the judgment.
Why was the judgment entered 2 years after the conviction?
They stretched it out and basically stretched the court dates out. And that's what they do at courts. They stretched out for 2 years, so I just used that 2 years to just, be positive, work on myself, and just exceed to my full potential, really.
With the entry of the judgment, what was the penalty?
It was 10 years of probation, state probation. My probation officer, she had me on enhanced for 3 months, and then she dropped me down to regular state because of, the schedule of car sales and everything. Never failed a drug test. I always pay my fees on time. I'm just, I guess, because I'm just not really an issue for her, because I just do what I'm.
Commissioner Vaughn, question.
Oh,
Is this your first conviction?
This is my second conviction.
Have you been in any trouble since this last
No, ma'am.
arrest? What was your first conviction?
It was possession with intent to sell. It was when I was in college. I was low on money, and I just made a dumb decision with friends that they're not friends anymore, because they're all the way in Memphis when I was in college, but just a boneheaded decision.
gentleman that you brought with you like to address the commission? Yes, sir.
Aaron White's been with us, since June, July?
What's your position? I'm sorry, sir.
I'm sorry, I'm one of the managers there.
Okay.
I'm a lot manager, and I kind of do a little bit of everything there from help.
Let me let you move to the microphone there, sir.
Sorry.
That's fine.
I do a little bit of everything there. I'm a lot manager, so ultimately I back up every department in the building, from service to parts to sales, help out with the sales managers and the general manager and even the owner with getting certain things. But Aaron, like I said, he's been there since August. From what I know of him and from the opportunities that I've had to work with him, he's honestly a really good guy. He seems like he's trying to do everything correctly, just trying to get everything in line to succeed, to provide for not only his family but his kids. From what I know of Aaron, he hasn't given me any doubt of anything different, but truly a good guy who made some bad decisions when he was younger. But I mean, he's supposed to. He's on time. He stays late when he's supposed to, or not when he's supposed to, but when he's needed. He comes in on his days off when we're short-staffed. He's always willing to help out whenever anybody needs any help with anything, whether it be with me getting down the street or even helping out some of the other sales guys just to make the business run more smoothly and efficiently. So,
Are you his direct supervisor?
I am not, sir.
So you wouldn't have a hiring or firing, you wouldn't be the decision maker necessarily in his situation?
I would not be a decision maker, but I do have an input as far as if I think someone's not doing what they're supposed to be doing or what is expected of them, then yeah, I do give the two managers that do have the decision making my input on who should stay and who should not, or stay and who shouldn't go. And then at that point, it's up to them on whether or not if they keep them or let them go. There's that I have had issues with in the past that they have let go because of my influence on.
How many sales managers are at this dealership?
We have got the general sales manager. We've got a used car manager. We've also got another desk manager, and then of course we have our general manager / owner, Mr. Rezzi. So,
I think the managers there, they're not here, and this is not to diminish your importance in being here. We're glad to have you here.
Absolutely.
But do your managers understand the seriousness which the commission takes such matters and why we're here?
Yes, sir. Right now, the main reason why the managers couldn't be here, Rezzi is actually in Korea, South Korea, in a huge meeting with Kia's main headquarters in Seoul, Korea. Brent, who is our used car manager, is actually on his honeymoon. He just got married Saturday. And then we've got just the other two managers, Mr. Dave Sutton and Frankie McMillan. And with the lately, Unfortunately, there wasn't enough coverage to cover the desk to be able to attend, and that's why they had sent me.
Commission members, questions?
Chairman Roberts, one thing after Commissioner Vaughn's question, staff just pointed out, we don't have a copy of the first conviction that was referenced. And looking at his sentencing on the conviction we do have, it says that this count's running consecutive to case number 98536. I'm not sure if that's the one he's referencing or not, but it does look like we're missing at least one document from the application file.
Mr. White, did someone assist you with filling out your application, or did you do that yourself, do it all yourself?
Yes, I did it myself, and of course, the human resource was with me, and we made sure everything was there. They asked me if I have prior felonies, and I did say yes. On check, they just pulled up the last conviction, so I don't know how.
Pulled up the last conviction?
Yes, which is what we're here for.
How would the HR staff there pull up your last conviction? Is that
with the background check?
Background checks?
It's a rule,
Director
we
Shaw.
ask that the applicant or the dealer applicant supply the final adjudication order from the courts that would be affected. So that would go back to the dealer or the dealer and applicants to supply that information to us, just for general information for the commission.
Would it be required as part of the application process to provide the paperwork from a prior conviction if outside the 5-year window?
Anytime they indicate that they have been convicted of a prior felony, we would ask for the adjudication document from the court to make that determination.
Commissioner Jackson, so when we got the application and the attorney just mentioned, also included another number, shouldn't we have not checked?
Yeah, I should have noticed that, but I didn't. It just says in the little box there that this sentence runs consecutive to another case. That case wasn't provided. And that would indicate, since this was entered in 2016, that his prior case is probably still under some kind of probation or supervised release. And if this is running consecutive, then I believe consecutive means that his 10-year sentence would end when his other sentence that we are not familiar with at the moment would end. So it might push off his date further.
From my understanding from with the court, when they say they run consecutive, they put it all into one. That's from what I understand from what my lawyer told me and what the judge had told me. That's why I don't.
Commissioner Jackson, do you recall the first incident of the intent to sell whatever drug it was? Do you remember what year that was?
It was like 2008, 2000. Yeah, it was. May have been maybe 2000. It may have been 2010, 2012. It's just that it's been so long. I just remember I do remember being in trouble years ago, but I just thought with it being so far away, I did not know if that, when I violated, if they put that all together. And I'm going by everything for what my lawyer told me and what the judge mentioned to me as well.
Where are you working currently, Mr. White?
I am on where we did the appeal here at Parkside Kia. Before at Kia, I was at, like I mentioned, with U.S. Cellular, with basically cell phone sales.
What are you doing at Kia now? Are you you're gainfully employed at Kia right now?
Yes, sir. And we were going off of the appeal to come to the front of the court.
What are you doing there?
Basically, just when I first got there, we were doing sales, and then we got the letter from you all, and so they had me put on leave until we come here to do the appeal.
Well, it sounds like my fellow commissioners members have some concerns about the full disclosure. I have some concern because you don't have a direct supervisor here with you. It's not required, but I have some concerns about that. address this unless we were to ask you to update your application and bring a supervisor with you or have a letter from the supervisor, something like that. Thoughts on the case that we have?
I would echo that. I think the other concern we have is simply the relatively lack of time that we've had with this dealership. As I think you said, you began working there in August, so that's only been 3 months. It feels like there needs to be an update to the application to make the paperwork complete and allow some additional tasks, maybe to the next meeting, to evaluate the full application at that point.
I would tend to agree. I'm not going to approve today, summarily today. I think it needs some more look. Do your employers know about the other conviction? They know about it?
Yes, sir. And the other conviction, like I said, it was like in 2011 or 2012. They had said the last 3 years. So the last 3 years, I put.
Let you move one step closer.
I'm sorry.
That's all right.
It said for the last 3 years. So I put for the charge that I'm here for now. Now the charge I was like in 2010 and 2011, you know, that was like what I violated to get to where I'm at now. But it just says for the last 3 years in 2016, and that's what I put. So, I mean, I just didn't think that was. I didn't know.
For the new commissioners, if there's a denial today, an appeal can be made as soon as the next commission meeting, which would be in January. Commissioner Clayton, excuse me.
What testing program do they have at Kia store?
Pretty much, we've got random drug tests. At any point, you can be subject to a drug test for any reason whatsoever, and it's random. There's no time frame. It's not like every month or your violation of ultimately failing that test is immediate termination.
Follow-up question. Was there pre-employment drug testing done?
Yes, ma'am. We do a pre-employment drug test on every applicant before a position is offered, along with a background check as well on every applicant as well before a position is even offered.
Please speak into the mic. Thank you.
Sorry. What part of that didn't you not hear? I apologize.
If you want to go back.
Yeah, no problem.
To about the middle.
Okay, no problem. Basically, a background check and a drug test is done on every applicant before a position is offered to the individual. So.
Point of clarification, can the commission grant a license with conditions being met, or is that?
With what being met?
With certain conditions being met?
Sure, I believe so.
Necessarily suggesting that. I just wanted to let the commission knows of its options.
Commissioner Jackson, I was thinking along those lines too. Great mind thinks alike.
I wasn't baiting you, sir.
I would like to just clarify one thing, if I could, before we move forward. I know that the applicant did indicate that the question was, had they been convicted of a felony within the last 3 years? And just to clarify for our new commissioners, the question on the application for licensure is, have you ever been convicted of a felony? So that may be a policy of the dealer licensee, but for the commission's purposes, the question is, have you ever been convicted of a felony?
I think some latitude could be granted due to the fact that their staff is out of place. One being in South Korea, the others are a little short-handed. I know how that is.
Meeting again until January.
Correct.
Gee.
Commission like to see a letter from the general manager of the dealership accompanied with a update of the application.
Recommend two things.
You certainly can.
One, that we get the application totally up to date so that we know exactly what's there. And secondly, that we obtain a letter from the dealership guaranteeing 12 months, consecutive months of testing on this guy. That he said the management to certify that to us, that will be done.
Currently, you do random drug testing?
Correct, they're random drug tests.
I'll take one every month, sir.
I put that in the motion.
Have a motion now.
Then it's-
Okay, and the motion is to update the license and a letter from the general manager of this licensed Kia dealership by the general manager stating that there will be a random drug test within the next 12 months for this applicant.
I think the motion needs to state that, just to make sure that his other conviction is for what he claims, possession with intent to sell cocaine, that doesn't come back as, no, grand theft auto or something like that. That we're going off the assumption that it is for possession of cocaine without seeing it. We can't know for sure.
Please add that.
So we don't have a second yet, so we can continue to work on this motion. That part of the motion would reference update verifying the stated conviction for cocaine.
I believe
sales.
you said it was possession of cocaine.
I don't want to get into the legal part of this, I'll get that.
Yeah, no firearms, nothing. It was just strictly.
I may, sounds like the motion is to conditionally approve the license with the requirement of providing an updated application so the staff can confirm that the previous conviction is as stated here today, along with a letter from the dealer management of a continuous monthly drug testing for the next 12 months will be performed on the individual. And upon receipt of that letter and confirmation of the prior conviction, that the condition approval be fulfilled.
If I could, Commissioner, would it be the intent, if those things are received and that it meets the terms of licensure, would it be the intent that the staff move forward with the approval process, or would it be the will of this commission for the applicant to reappear before the commission in January?
I think we could allow the staff to make that determination, to make the approval without our further input, as long as those conditions are met and the staff determines those conditions are met, the license could be granted.
Thank you for that clarification.
Commissioner Tomaso, for my fellow commissioners, what does a drug test cost?
Yeah.
Okay, so it's not burdensome for the dealership.
You can address this
Certified that
concern.
it's done.
I like, this is not an objection to the motion on my part, but can we dictate drug testing? It's not in our,
I think anything they'll
It's not
agree
in our
to,
rules.
anything they'll agree to, we can put in there. Whether or not they'll agree to it, I guess that's be whether or not staff issues a license or not. I would point out enforcement on that might not be readily clear how we would enforce that. Other than, I mean, we'd have to, I guess we could ask them to, I'm not sure, I'd have to think on
I
how
don't
we'd
think
actually
we would even
enforce
wanna-
such a provision.
I don't think we'd either want to go there on enforcement. I think that'd be as much for the benefit of the dealership that he works for.
Surely if the
and the facility.
dealership wants this guy on board, they'll be happy to issue a letter, and they would be happy to even supply us a letter in 12 months confirming that it's been done every month. If they're not willing to do that, turn it down, let's move on.
Then
Well,
we have-
that's my point exactly, because he's only worked there 3 months.
We
Now,
could
the general
possibly-
manager, I mean, does he really know this gentleman? I mean, and will he take that liability? I mean, given it, he needs to be there more time and create credibility, then I would say, yes, I would sign.
Let me,
We could potentially have them come back at renewal and provide proof that,
let me verify first. We're in the discussion mode. Let me verify first. We have a motion. Is that the motion? Okay. Now,
Let's add what was just said. That if he
Is there-
does,
is
if
there a
the
second on
dealership
that?
doesn't guarantee
Right.
that that'll be done, then we turn him down automatically, done, gone.
Okay, so we do have that motion now. We can,
Second the
continue and-
motion.
and, I'm sorry, we have a second, thank you, to my point, second.
Commissioner
Now we
Levy,
can,
second.
now we can, I think we want to read the motion back, offer up discussion again, and then we'll vote.
Want me to read the motion? All right. Motion is that staff can approve Mr. Aaron White at Parkside Kia once he updates his license, including showing that he does have a conviction for a felony for possession of cocaine with intent to sell at some point prior than the copy of the conviction we currently have. Receipt of a letter from the dealership in support of employing Mr. White, as well as agreeing to drug test Mr. White once a month for 12 months.
Or the dealer principal, exactly.
A letter from the general manager or dealer principal in support of employing Mr.
Okay.
White.
Commissioner Clayton, is that your motion?
That's it.
Commissioner Levy, is that your second? Okay, we're open for discussion, if there's any.
Commissioner Jackson,
Commissioner Jackson.
and the reason why I think I support the motion is because staff have an error since I've been on this board, but there was an error from the staff, so that's probably why I would support this particular motion.
Further comments or discussion of the motion? Hearing none, chair calls for roll call vote on the motion.
Chairman Roberts.
Yes.
Commissioner Lee.
Yes.
Commissioner Galvin.
Yes.
Commissioner Clayton.
Yes.
Commissioner Fox.
Yes.
Commissioner Kramer.
Yes.
Commissioner Jackson.
Yes.
Commissioner Melton.
Yes.
Commissioner Murray.
Yes.
Commissioner Trickett.
Yes.
Commissioner Norton.
Yes.
Commissioner Parr.
Yes.
Commissioner Vaughn.
Yes.
Commissioner Tomaso.
Yes.
Commissioner Levy.
Yes.
Commissioner White. Commissioner Evans.
Yes.
Motion carries.
Mr. White, you might want to get a copy of that motion or
Yes, I
instructions
was
from
gonna-
legal before you,
Yeah.
okay. Okay, good luck, sir.
Who would I get that from, Mr. Roberts?
Who, Director Shaw, who would you like for Mr. White to contact?
Ms. Malik will assist him.
Okay. They'll give you your instructions and you take back to your duty. Good luck, sir. Thank you. All right. All right, Bernie Dawes, Cookville Honda. Morning, Mr. Dawes, and Mr. Reddish, if you would read to the commission the reason for the denial.
Review of Mr. Dawes' salesperson application and judgments does reveal a conviction for a crime involving moral turpitude. In the case of Mr. Dawes, the documented conviction is for possession of cocaine over half a gram for sale on October 10th, 2008. Mr. Dawes received a sentence of 8 years. Application may be denied until October of 2021.
Dawes, you have a sentence of 8 years?
Yes, sir, it's about done. I've been on probation.
Probation, okay.
Outside, it'll be done next October.
Okay. Probation ends next October, or the sentence ends next October? Which way was that, Mr. Reddish? Sorry, I didn't get that. I was looking at the,
What was the question? When does the sentence end?
when's the sentence end?
The November 3rd, 2017. So he could be denied until October of 2022.
Mr. Dawes, if you'd like to address the commission.
Yes, folks. Since that was a turning point in my life, I helped open Freedom Ministries in Christ in Cookville, Tennessee in 2009 and was on top of the board, helped run that until 2012, and just some things changed through there to help people with addiction problems and things like that. And it's still going. They would like me to come back on board. It's just, it takes a lot of time and things like that. And I'm thinking about going back in that. As far as that, I'm not the person I was back then.
Any other crimes on your record?
No, sir.
Okay. Questions for Mr. Dawes?
Commissioner Lee, bring me back up to date. This happened in 2012, and what's proceeded since then?
No, it happened in 2008 was the charge. And I helped open Freedom of Christ Ministries in Cookeville, Tennessee, and I think it was 2009, if I remember right, 2010, in that area, along with Steve Taboo.
There till just recently?
Till about 2012, I was there helping with that, yes, sir.
What's happened since 2012 till today?
Right there, people, just to be honest, people with addictions probably gets kind of tedious a little bit, and I've just been doing odd things and things like that, clean up in detail.
Were you employed during that, after 12, or has it just been random jobs?
I've been cleaning cars and things like that, as far as that goes through Cookeville Honda.
Gentlemen, you brought with you, like to address the commission?
Steve Cooper, General Manager of Cookeville Honda. I've known Bernie 5, 6, 8 years or something now. I've been with Cookeville Honda for 10 or 12 years. He's a good guy. Put him back in the wash bay, and he's done everything he's supposed to do. He's a class act guy.
I have a question. How long have you been clean? When's the last time you used illegal drugs?
It was back in 2008.
Drug testing during any of this time?
Yes, they go through that through probation and things.
Honda dealership have any drug testing programs?
Yes, they do. They have a random drug tester.
Other questions?
Commissioner Jackson, just for clarity, this is addressed to the staff. When normally on this, I see possession of 0.5 gram of cocaine with intent to sell. Is that normally what the law attached to that if someone is caught in their possession, say with 0.5 gram of cocaine? Is that what they normally?
I believe when they're over a certain amount of cocaine that they make the assumption that it was for sale.
This is to the petitioner. When you was arrested back in 2008, tell me about that. What happened there?
What happened, I was driving down the road and then committed a moving violation.
You had the cocaine in your possession, and when they pulled you over?
It was in the back of the car, yes, sir.
Okay. They didn't catch you in no act of selling to someone?
No, sir.
Okay.
Just concerned.
I just been curious about that. Commissioner Jackson, I motion that we grant him the license.
Second, Commissioner Vaughn.
Commissioner, sorry, we have a motion to grant the license, Commissioner Jackson, seconded by Commissioner Vaughn. Discussion of the motion. Hearing no discussion, Chair calls for a roll call vote.
Chairman Roberts,
Yes.
Commissioner Lee,
Yes.
Commissioner Galvin,
Yes.
Commissioner Clayton,
Yes.
Commissioner Fox,
Yes.
Commissioner Kramer, Commissioner Jackson,
Yes.
Commissioner Melton,
Yes.
Commissioner Murray,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
Yes.
Commissioner Parr,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Tomaso,
Yes.
Commissioner Levy,
Yes.
Commissioner White, Commissioner Evans.
Yes.
Motion carries.
Congratulations, Mr.
Thank you,
Hall.
folks.
Thank you. Mark DeBusk, Cookeville Honda. Is this a different store, a different location? Okay. I noted one said pre-owned. Is that,
Bernie works at our pre-owned store. We do have a separate lot.
okay,
yes.
this is the new car store?
Yes.
Okay, all right. Mr. Reddish, could we hear for the reason for denial?
Sure. Review of Mr. DeBusk's salesperson application judgment does reveal a conviction for crime involving moral turpitude. In the case of Mr. DeBusk, the documented conviction is for 3 counts of theft on August 27th, 2010. Applicant received a sentence of 5 years at the Tennessee Department of Corrections and another 12 years of probation. Application may be denied until August of 2034.
Ask what what was the theft involved with that you were convicted for?
I've unfortunately decided to drink myself to death, and I ran out of money. I was job done. I failed at that too, but then I ran out of money.
Let me let you lean forward just a little bit, sir.
I would write checks from one of my accounts to and deposit it in my other account, and I would withdraw money. And I have, it was originally $9,500 sum, and I've paid it all back but $2,200. And if I could pass, I've got some letters from,
Go right ahead,
from
yes,
my sponsor.
Yes,
I
go
don't
right
have enough of them. I think there's 10.
You were stealing from yourself and then writing bad
Oh,
checks.
I don't know, kiting checks. It was my personal account. I would write one from my, and put it in my account at one bank and then do the other at the other, and it totaled $9,500.
Well, as far as the theft itself goes, I don't understand the charges. I don't know that it matters. They're both,
I guess it'd be from the bank.
I'm sorry.
It'd be from the bank.
Step
Basically, he's writing
bank.
checks that the bank couldn't cash.
Regents Bank and SunTrust, and I have made restitution. I still owe Regents $2,200 and some odd dollars.
My reason for asking was it direct theft from consumers?
No, sir. Unless you, I mean, a bank, I mean, but that's
That's
just as bad as far as I'm concerned, I
Well,
guess.
Well, that's,
I would like to thank Mr. Cooper for giving me the opportunity, and I thank Howard Elliott for driving from Knoxville. Howard, I haven't in the last, I guess, 8 years, but I did work probably 16 years with him in the car business.
would either of the gentlemen like to address the commission?
Mark is a very, very professional car salesman. He's probably one of the best I've worked with in 30 years. He's a class act guy, had a drinking problem, and hopefully AA is going to fix it someday. I don't know.
The other gentleman?
My name is Howard Elliott, and I first got acquainted with Mark DeBusk when he joined the Harry Lane Lincoln Mercury store in Oak Ridge, and that was in February of 1996. Harry Lane and Jimmy Cogdill were in partnership at that Lincoln Mercury store, and they also had a few other stores. One was the Oak Ridge Chrysler Dodge Jeep store at 1005 Oak Ridge Turnpike. When Mark was hired in '96, I had been with Harry and Jimmy at the Oak Ridge store, Chrysler store, for 8 years. 28 years later, I'm still at the Chrysler store in Oak Ridge. Harry has passed and Jimmy Cogdill has sold that dealership, but I'm still there. And during that period of time, from the time that Mark DeBusk was hired for the Lincoln Mercury store until he left the Chrysler store in January of 2006, I had a great deal of experience with Mark. After Mark was at the Lincoln Mercury store for about a year, Jimmy was able to get Harry to transfer Mark over to the Lincoln Mercury store because it was very, very obvious that Mark was tenacious about making the deal. Very good at what he did. And during the time that I have been at the Secret City, now it's Secret City Chrysler Dodge Jeep, formerly Oak Ridge Chrysler, during that time, I have served as salesman, sales manager, finance manager, general sales manager, and GM for the store. I say that to indicate the breadth of my experience with the people that have come through our dealership over that 28-year period. And I can honestly say that Mark DeBusk is by far the best salesperson I have ever been in contact with. Also, I have been aware of some of the problems that Mark has had on a personal basis. I'm also aware that he has changed his life around. And I think that if the commission can grant Mark a sales license, that it will be serving the state of Tennessee well, because we will be able to fantastic car salesperson in our state. Thank you.
Thank you, Mr. Elliott. I'd like to add to the comment of Mr. Elliott. All very well taken, but I was especially taken by the one when you stated that it would serve the state of Tennessee well, and that's why we're here. Thank you, sir. Busk?
I don't know that I deserve it. I mean, that means more to me. I want a sales license, but the fact that they care about me that much means more to me. Sorry for what I did, and I just want to go to work.
Gotcha. Any questions for Mr. DeBusk?
Mr. Vaughn,
Commissioner Vaughn?
have you had any trouble since this conviction?
Last 4
Well,
years.
I have roots in Cookville. My family's there, but I've done the traveling salesman roadshow, and I just, if that's the way I got to make a living, sir, I just pretty much not do it. It's not conducive to sobriety. Anybody that can do that, I take my hat off to them. Everybody hates to see you show up on the property. I'm sure you all are aware of that, so it's not a good life.
Other questions?
I'd like to make a motion that we grant the license.
Second it.
Commissioner from, I'm sorry, a motion by Commissioner Vaughn to grant the license, seconded by Commissioner Trickett, I believe it was. Discussion of the motion. Chair, here's no discussion. Calls for a roll call vote.
Chairman Roberts.
Yes.
Commissioner Lee.
Yes.
Commissioner Galvin.
Yes.
Commissioner Clayton.
Yes.
Commissioner Fox.
Yes.
Commissioner Kramer.
Yes.
Commissioner Jackson.
Yes.
Commissioner Melton.
Yes.
Commissioner Murray.
Yes.
Commissioner Trickett.
Yes.
Commissioner Norton.
Yes.
Commissioner Parr.
Yes.
Commissioner Vaughn.
Yes.
Commissioner Tomaso.
Yes.
Commissioner Levy.
Yes.
Commissioner White. Commissioner Evans.
Yes.
Motion carries.
Congratulations. Thank you, gentlemen. Christopher Rogers, Ray Vernier Ford, Clinton, Tennessee. Okay, yes, sir. Go ahead and pass those out. Mr. Reddish?
Mr. Rogers, salesperson application judgment does reveal a conviction for a crime involving moral turpitude. Mr. Rogers was convicted for domestic assault on January 20th, 2012. It was a misdemeanor. He received a sentence of 1 year probation and was to complete alcohol rehabilitation. May be denied until January of 2018.
Was a misdemeanor? Okay, all right. Rogers, would you like to describe to the commission the
Well,
what
I'm
brought
very
you to-
embarrassed. I'd like to say first off, back during that time, it was beginning the end of a 20-year relationship and, marriage. And anyway, one thing led to another. Of course, alcohol was involved at that time, and I cut the spark plug wires on my ex's car. I'm very ashamed of it. I'm not proud of it. And since then, we've both moved on. We both live for our grandkids now. We have two grandchildren, and I just, I was guilty. And I just asked the board to give me their consideration.
Is this the extent of it, sir, cutting the spark plug wires? Is this the extent of the action that led to this misdemeanor conviction?
Well, they was a lot more involved into it. I discovered this
Well, I mean, just-
internet romance going on, and it
No,
just,
I didn't mean that. I didn't mean to.
and it was just kind of, bad, you know, and I'm ashamed of it and embarrassed.
I just
you know.
meant the scope of what you were arrested for and convicted of was,
Yes.
that action is.
Yes.
Is for the spark plug wires.
I cut the spark plug wires on her car, and I got arrested. And of course, I got a big mouth, you know, and I made a big fuss about it. And you know, they took me to jail and 5 hours there, and don't want to ever go back.
Expensive spark plug wires, it sounds like. I just didn't know that, Mr. Reddish, misdemeanor, can someone explain that just for my own edification?
I mean, we're allowed to, a crime involving moral turpitude doesn't require a felony. I think we just saw domestic assault, and it's fairly recent. So I think that's probably why this memo was put out. I probably just looked at the sentence length and
I think the commission's struggling with the crime of assault for damage to a vehicle. I think the implication that we would have all presumed was that assault was somehow connected to some type of bodily injury or threat to bodily injury. Do you have any additional facts regarding the conviction?
The judgment he turned in also, it indicated that this count was to be served concurrently with other prior cases. So that's probably the other reason it was denied, that we thought there were other convictions he wasn't revealing.
Let's go back to that. And
It was the
that's my
same
question.
thing, sir. During this period of time for about 3 months. In fact, she got arrested for domestic violence. And so they took the 2 convictions, you know, during the same period of time, and they run it together, and I served 1 year on probation, and then that was
Layman's
how I
terms,
did that.
which I very much qualify for that, but
Yes.
you pled out for spark plug wires.
Right.
All right. Now, there were other things negotiated in there. Anything outside of your domestic situation that you were pleading out and taking the spark plug wire conviction? Anything involving the public, is all of this about your domestic situation?
It was just domestic at home.
Okay.
It wasn't, nothing to do with the public or anything, but, and we've long since separated shortly thereafter, so.
I hear no discussion. Is there a motion?
I'd like to make a motion that we grant the license.
Commissioner Jackson, second.
Motion to grant the license, Commissioner Vaughn, seconded by Commissioner Jackson. Any discussion of the motion? Hearing none, chair calls for a roll call vote.
Chairman Roberts,
Yes.
Commissioner Lee,
Yes.
Commissioner Galvin,
Yes.
Commissioner Clayton, Commissioner Fox,
Yes.
Commissioner Kramer, Commissioner Jackson,
Yes.
Commissioner Melton,
Yes.
Commissioner Murray,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
Yes.
Commissioner Parr, Commissioner Vaughn,
Yes.
Commissioner Tomaso,
Yes.
Commissioner Levy,
No.
Commissioner White, Commissioner Evans.
Yes.
Motion carries.
Congratulations, Mr. Wright.
Thank you.
Okay. One in need of a restroom break.
Yes, sir.
Yes, all right. We'll reconvene.
Let's go run the camera. Solve all the problems.
see they sold them preferred warranty.
How does it feel you don't have to go to the dealership anymore?
Well, if there's
We
not,
let Mr. Clark know you'd have an opportunity. Mr. Clark communicated that he would show up, and he is aware that we're going to discuss his dealership. It doesn't appear that he's here.
have an interest in whether or not this license is granted?
Yes, he's the owner.
Is Mr. Clark in the audience?
Well, I don't know if we want to discuss the case if there's no appeal. Double check outside. We might represent something that he wouldn't agree with.
We're checking in the corridor and see if by chance he's out there.
Anyone recognize him or know that he was here earlier?
Ness is checking to make sure he's not out in the hall or didn't check in earlier.
We've made a thorough search for the dealer making the appeal, Budget Auto LLC. It's not present, so that application has been denied. Is that correct?
Correct.
It is correct. We would, to uphold that denial, we would need to vote that way or a motion. Is there a motion to uphold the decision to deny the license?
I'd like to make a motion that we uphold the denial.
Commissioner Jackson, seconded.
Motion to uphold the denial by Commissioner Vaughn, seconded by Commissioner Jackson. Any discussion? Hearing none, chair calls for roll call vote. A yes is for the motion to denial. To deny. Ms. Shaw?
Chairman Roberts,
Yes.
Commissioner Lee,
Yes.
Commissioner Galvin,
Yes.
Commissioner Clayton,
Yes.
Commissioner Fox,
Yes.
Commissioner Kramer,
Yes.
Commissioner Jackson,
Yes.
Commissioner Melton,
Yes.
Commissioner Murray,
Yes.
Commissioner Trickett,
Yes.
Commissioner Norton,
Yes.
Commissioner Parr,
Yes.
Commissioner Vaughn, Commissioner Tomaso, Commissioner Levy, Commissioner White, Commissioner Evans.
Yes.
Motion carries to uphold the denial.
And on your agenda, the staff has been notified that Car Express LLC will not be here today.
That matter is settled administratively prior to the hearing.
Need a motion to approve that? If that's done administratively, I guess we don't need a motion to approve.
We do not need a motion.
Okay, very good. Ms. Shaw, Executive Director report.
Morning, Commissioners. I would like to, in addition to the general information that's in your packet on the licensees and the number of licensees that we have, I'd like to recognize our new commission members and welcome them to the board, Commissioner Melton, Commissioner Lee, and Commissioner Kramer. Commissioner Kramer will be part of our legal review committee in the future, and Commissioner Lee will be joining our our Rules Committee, which will be immediately following the regularly scheduled commission meeting today. I'd also like to recognize a couple other commission members that we have who have been very helpful to me in this last interim or this last quarterly period, which Commissioner Norton participated in some of the testing of our, what you will come to know is VO, which is Versa Online license issuance and renewal processes, and our staff worked with his staff and at their headquarters office in Franklin, and we completed some end-to-end transaction testing, and when we put our team with his team, you would have thought they'd been working together for years. They just fit together like hand in glove, and we got some very valuable information, so I'd like to thank him for that. And Commissioner Parr actually made himself available and came up one day as we were going through some of the initial system review and application review on the VO transactions. And as I mentioned to some of the other commissioners earlier, if I know you've got an area of expertise in one area or the other, I may reach out to you for that area of expertise, because I think, as Commissioner Parr had expressed over a period of time, he has a lot of experience and knowledge in the IT background, and so we've been very fortunate to have our commission members be willing to serve in some of those capacities and to add their other professional skills and expertise to this industry. So I'd like to thank them. For the new commissioners who are not familiar, each time when you attend the commission meeting, you will have a packet with your name. It'll be basically an envelope at your nameplate. Anything that you need to complete, if there's paperwork, and you don't have to fumble through there now, but they're pretty much customized. Sometimes there's some standard documents that need to be signed or completed by that particular commission member. We would just ask that you would complete those documents before you leave. It helps us to expedite the processing of any per diem expense claims or complete files that we have in the office. So if you would, before you leave today, check those files. Also, if you're submitting, you're already set up to submit your expense claims with us. The new members will not. We'll be working with them, but you can put your receipts for your overnight stays, travel, in the envelope, and we will take those back offline and be working with admin staff to complete that process. Those of you, I think you're already aware that we are making photos for your ID badges, which are needed for entry to the building and access to the parking garage. And Miss Amber Ryder in the back, if you haven't already worked with her, will be assisting. So if you haven't had a chance to have your photo made yet, before you leave today, please see Amber and get your photo made so that we can complete that badge process. There are, and I think this will be discussed a little bit more when we get into the legal report, but there has been some restructuring in our legal division, which I think Mr. Glendorf will talk about that. But they have put together teams that will make some changes in our legal review committees, and I'm going to leave that for Mr. Glendorf. I just kind of wanted to put that out there and make sure that we got that on the table. Continuing on with the director's report, since the last commission meeting in July 25th, 2016, the following activities have occurred. The dealers opened or relocated last quarter 55 active licenses as of October 10th, 2016. Dealers, 3,760. Applications in process, 38. distributors, manufacturers, 132, auctions, 32, representatives, 598, salespersons, 16,467, dismantlers, 271, RV dealers, 28, RV manufacturers, 60. Motor vehicle show permits issued since July 25th, 2016, 4, with associated revenues of $800. Complaint report, open complaints as of July 25th, 2016 to October 10th, 2016. Number of complaints open, 129. Number of complaints closed, 159. The annual sales reports, which were due February 12th, reported that in 2015, 1,294,979 vehicles were sold, and 3,660 recreational vehicles were sold during the same period of time. That's excluding any dealers who reported late after the standard deadline. Late annual sales report collections for fines and penalties associated with late reporting was $48,300, and the listing was sent to the county clerks on April 19, 2016, identifying the eligibility for dealer plates. Revenues associated that were submitted to the Department of Revenue for FY15 for a system known as Nimbetus total $40,000, and the disciplinary action report total collected fines and fees were $121,900. That concludes my report.
Thank you very much, Commissioners Parr and Norton, for your help with the core system. And, also, Ms. Shaw, would you read the list of members for the Rules Committee in case someone...
Chairman Farrah Vaughn, Commissioner Lee, Commissioner Fox, Commissioner Murray, and Commissioner White.
12 o'clock today. Any questions for Director Shaw on her report? Hearing none, is there...
Commissioner Jackson motion that we adopt the director's report.
Okay.
Second.
Motion to approve, Commissioner Jackson, second by Commissioner Vaughn. Discussion. Hearing none by voice vote, yes would be for the motion to approve and no would be to not. All those in favor of the motion to approve, say yes.
Yes.
All those in favor say, all those against say no. Thank you. It's approved.
Thank you.
Mr. Reddish, legal report. And Mr. Glandorf is the chief litigator for
Chief Counsel.
Chief Counsel Department.
Yes, if I could, I'd like to take a moment to kind of address all the commission members and give you all an update on a restructure that we're having in our legal division, as Ms. Shaw mentioned earlier. I'd like to introduce you all to Ben Glover. Ben Glover is an attorney that's been with our department for about 1.5 years now. Ben currently provides all legal advice to the Architects and Engineers Board, the Accountancy Board, and also Consumer Affairs Division upstairs. The restructure, I'm introducing you Ben because he's going to be part of the restructure, and also Sarah Page, who's sitting down right there. Sarah Page is a litigator in our department, and she's been a litigator for 9 months, maybe roughly 9 months with us, and she came highly recommended from the Secretary of State's office where she was working at previously with the Administrative Procedures Division. And both of them are both graduates of the Belmont School of Law. Yes, I got it right. So in legal, we've been trying to create more efficiencies with our personnel, and over the last 6 months, we've been trying to come up with a plan to do that. And we've decided to go with a restructure of how we actually break out the work that all of our attorneys do for each of the boards. Currently, we have one board attorney that is assigned to certain programs, and they handle all of the board's legal business and along with the complaints that come in, and they actually get authorizations for those complaints. We send out consent orders, which is basically a document saying, we brought this to the board. These are the facts as we see it. The board's authorized us to settle with you. You can return this back signed to us with payment and settle it. If not, you can either tell us that or just say nothing, and we'll send it to a litigator, and they will just litigate the case. Sarah's a litigator, and she's done many motor vehicle cases in that instance. What we notice is that with that process, we generally have a board attorney, such as Matt, who would read that file, come up with their own findings, facts, get an authorization, then he would transfer it to someone like Sarah, and then she would pick up the file cold, read the whole file, and then move forward with the litigation, filing the appropriate legal documents to do that. So what we're going to do is our restructure is going to make it so that there would be a team of attorneys that could provide services, not just the Motor Vehicle Commission, but multiple boards. And so the way that the restructure would work is that you would have one board attorney who would give all legal advice to the board, come to the meetings, and run the meetings. And they would do everything except for reviewing the complaints and providing authorizations for the complaints. What we would have is we would have a team of 2 attorneys who would actually review all of the complaints and present them to you on the legal report, and then receive the authorizations. They would send out the consent orders for settlement, and then if they didn't settle, then they would litigate their own cases. So the way that we've restructured it is that Ben Glover would actually be your board attorney who would sit here and come to the meetings in Matt's stead, and he would be doing everything that Matt has done except for the legal report. So anything that had to do with applications, anything that had to do with denials, anything that would have to do with creating any kind of application changes, documentation, also rulemaking, any type of rulemaking process that we would have, that would be Ben, and also during the legislative session for any bills that would be introduced into the legislature that would affect the Motor Vehicle Commission. Ben, along with myself, would be looking at those and then doing a bill analysis as to how does that change the law. So that would be Ben's role. That would be starting in January. Now, for the complaint review, which is all of the complaints that were received that you saw in the legal report, that would be done by a joint effort between Matt and Sarah. So Matt and Sarah would come down here, and it would probably be either both or one of them, and you would have the same legal report. It would generally be divided. We envision it being divided in half. Half of those would have been the ones that Matt worked on, and then however many that Sarah would work on. And so we would have the same process. You all would see the same process. It would just be one different person that's going to be presenting those to you. And they would get those authorizations, and they would go back and provide the relevant settlement agreements via the consent orders. And then if they did not settle, then those would be litigated by either Matt or Sarah, who actually presented those to you all. So we gain efficiencies in that we only have one attorney reading the file. And so we have consistency on the attorney who made the recommendation and the attorney that litigates the case. It's kind of like the birth of the complaint to the end of it. You would have one person do that. And then at the same time, we're going to gain efficiencies in being able to broaden the number of programs that we can reach. So for example, Ben would be the attorney to the Motor Vehicle Commission, the Architects and Engineers Board, and also the Accountancy Board, and then provide general legal advice to the Consumer Affairs. But he wouldn't be working on any complaint issues. Your complaint issues would be worked on by Matt and Sarah, who would have the same boards, and they would process the same complaints. So right now, Matt processes not only all of the board attorney work, but all of the 400 to 500 complaints that the Motor Vehicle Commission gets a year, which is either the largest or the second largest volume of all of our programs. But instead of that, he's going to be able to do half of all of the complaints between Motor Vehicle Commission, Architects and Engineers, the Accountancy, along with Sarah Page. So we think that we're going to gain a lot of efficiency in there. And that would be, for this board's purposes, it would begin in January at the January meeting. And I'll be here for that one. And what we're going to work on is a smooth transition. But so far as the board attorney work, it's generally the same from program to program. You'll still have your experts as to the relevant violations of the law. You'll still have Matt, who we talked about some issues this morning. He will still be processing complaints. And then you'll have Sarah also here, who's dealt with a lot of big issue motor vehicle complaints also. And then Ben, would you be your expert on your procedural issues, your applications, really working with Paula day to day, very heavily on that, and also for the appeals of the denied licenses. Does anybody have any questions on that?
Mr. Glover, Ms. Page, did you have a Professor Trost while you were at
Yes, sir.
Belmont?
Charles Trust was
a wonderful professor and a good friend of mine.
You're saying that officially, or is that on?
Oh, that's the truth.
All right, hold up your right hand. Ms. Page, would you like to speak to the commission or address the matters of Mr. Trost?
I had Professor Trost. He's one of the only people who says that tax law is as close to a murder mystery as you can get in the law. So he was an interesting.
Well, I've felt weak a few times myself upon seeing my tax situation, my income tax. Well,
And-
thank you very much. We look forward to working with
Thank you, thank you. And this is going to be department-wide for all of the, for our division-wide for all of our programs. So it's not just the motor vehicle commissions. All of our programs are going into this transition. And we hope that we'll be able to give more precise legal advice on issues of the board into the future. So thank you.
Thank you very much.
I believe Sarah had a case that she wanted represented. That's a settlement that legals agreed to that didn't make it onto the supplemental representations. You want to present that?
Good afternoon again, members of the commission. I am here on behalf of a litigator who is no longer with the department who worked this case. The case number for this, the complaint numbers, there's two, 2014-001491 and 2014-005931. In this case, it was discovered that through a consumer complaint that a dealership had issued 7 temporary tags to a gentleman who had purchased a vehicle. The civil penalty that was ultimately assessed against them was $3,500 at its initial consideration, which is $500 times 7 for each of those temporary tags. Through communications with counsel for the dealership and more further investigation, we discovered that while they did admit to issuing all of these additional temporary tags, it was in an effort to appease the consumer. The title was supposed to have been sent from a bank in Kentucky for the gentleman, the consumer, and it was ultimately lost. There's quite extensive evidence in the file that the dealership and the bank did not get along on this issue, and it took quite a while to resolve getting the title for the consumer. In an effort to appease the consumer, the dealership continued to issue temporary tags. Now, obviously, they are not allowed to do this, even though it's in an effort to help this consumer along, and the consumer was ultimately titled after that 7th license. The litigating attorney before me worked with counsel to try to find a compromise, considering the fact that they did try to help this consumer as best they could, and ultimately did get a new title for the consumer, so he's now registered and has his truck and he's ready to go. The settlement offer that the two attorneys came to was $12,500, which would be $250 for 5 titles, assuming you subtract 2 for the legal. $1,250, I'm sorry, I did that. Thank you. I saw them before, $1,250, that's $250 times 5 temporary title tags, subtracting 2 for the legal 2 titles they would have been allowed to issue. They also are willing to pay the $200 filing fee, bringing the civil penalty to $1,450, because this case had been set before a judge prior to settlement negotiations. So they have signed an agreed order in anticipation of the commission's approval, but obviously that is for you to decide. So I would make a motion that this new settlement be accepted for $1,450.
A motion? Commissioner Lee, who's the first? Commissioner Clayton made the motion. Commissioner Lee seconded. Any discussion? We'll just do this voice vote. Those in favor of the motion to agree with the legal department's request, let's say aye. Aye. Those that are opposed, say no.
As always, thanks, members.
Thank you.
All right, on the legal report, we discussed this earlier this morning, so everybody is aware. The first entry where it says discussion, we changed that to a letter of warning. And then we had some extensive discussions on entry number 14 regarding deceptive acts tied to service contracts and warranties. And we've brought the bill of sale and some other documents for everybody to review. Vanessa's going to pass out. And just wanted to get some discussion. I know Chairman Roberts, Commissioner Norton weighed in on this earlier this morning. So just so that everybody is aware of what they're discussing, just wanted to see if we want to go forward with a civil penalty today, or alternatively, if we want to table this to January.
The way the motion was crafted, are we approving, are these two separate actions, or are they one action?
We only motioned to table it. We never actually motioned to table it to any certain time. So we can say we tabled it until now.
I would
Now we
say-
can decide.
I would say that we look at the other cases for approval and then carve this one out separately. Was that consistent with the motion?
Okay.
If we could take a minute to look over the other cases with the exception of the one numbered
All right,
14.
so currently considered entry number 14 on the main legal report to be deleted, and
And then number 1 was a letter of warning.
number 1 to be a letter of warning.
Okay. If you'd look at that, please, before we enter into this one. Questions of this one? This legal review report go out online prior to the meeting?
It should have been distributed to everybody last week.
Okay. New members might not have gotten it. Okay. New members of the commission didn't see it. You weren't, that's normal. Problems there. So take
Everybody
your
else
time.
had a chance to review all these cases beforehand? And does anybody have any questions or comments they want to make on particular entries on here? Or a motion to adopt the legal report and supplemental? Correct, and number 1 being a letter of warning.
Second.
Seconded by Commissioner Vaughn. By voice vote, those in favor of the motion say yes. Yes. Those in favor say no. Okay. We can talk about number 14 now.
So the documents handed to you are what was formerly entry number 14 on the legal report. And we had some discussion on whether or not this deal file constitutes a deceptive act. A couple of things I want to point out is on page 2, if you look at line G on the bill of sale, you'll see they stated they sold a preferred warranty for $125. The next page gives some details about the warranty was, but legal certainly feels it's deficient. All it really says is 3 months or 3,000 miles. It doesn't describe what parts of the vehicle are covered or what situations would be covered. And again, they mention that it's a preferred warranty. If you go to the 5th page, it'll be titled "As Is, Sold Without Warranty." And they had the consumer sign that document. And in the fine print there, it says, "Seller identified above hereby expressly disclaims all warranties, either expressed or implied, including all implied warranties of merchantability or fitness for a particular purpose, and the seller neither assumes nor authorizes any other person to assume for it any liability or connection with the sale of this vehicle." And then below that says, "Notice, a vehicle sold without any warranty. Vehicle sold without any warranty, purchaser will bear the entire expense of repairing or correcting any defects that presently exist or may incur in the vehicle, unless the salesperson promises in writing to correct such defects." And then they had the purchaser sign that. The next page is the buyer's guide, so I gave some incorrect information earlier. They did mark as is no warranty, but they wrote service contract under systems covered, which everywhere else they refer to this as a preferred warranty, and here they just wrote in service contract. So that's kind of a summary of the documents from the deal file that we received that made mention to any warranty or service contract. And now we have a dispute arose down the road. For those who weren't here, we kind of covered this earlier this morning. Dispute arose as to whether or not some repairs needed to be made on a vehicle. The commission doesn't really get into warranty disputes, and so legal had recommended a $500 civil penalty for deceptive acts. And there were some concerns raised by Commissioner Norton, Chairman Roberts. So I wanted to present these documents and see if the commission feels that there is in fact a deceptive act present in this deal file.
How was the original complaint sent to the commission?
It was a consumer complaint.
To not having warranty coverage because the application for warranty coverage was denied?
Yes, the dealership wasn't fixing certain elements of this lady's car. I know there was a dispute about the radio, which is on, I think, the last page there, radio not working. And then there were some other issues that kind of come up after the warranty probably would have been passed, since it's such a short period of time, but they still thought, they thought they made the dealership aware of some issues going on, and then, I don't know, there are just a lot of disputes about whether or not the dealership should or shouldn't be fixing something. Obviously, the dealership, they need to.
Mr. Lee? I listened to some of that this morning, and I've looked at this right here. Honestly, I kind of agree with Commissioner Norton over here. They mark the car sold as is. Then when you get a service contract, that's a third-party vendor, that contract's between them and the dealership, not the service contract, but the as is that Chris Lee's not fixing that.
This is not a third-party warranty. This was, there's no evidence that this is a third-party warranty. This is a $125 fee charged by the dealership, and the only evidence we have as to what the warranty is or who covers it is this third page here, where they just wrote in 3 months or 3,000 miles.
One thing I would mention, though, you went to this WIO, and we use this in our dealerships too. Actually, if you can see where they've marked out, they had nothing promised, nothing owed. And apparently there was some discussion somewhere in that deal that the radio wasn't working. So they went back and amended that to tell them that the radio was working. If I'm looking at the paperwork here, I don't know who this preferred warranty is. Do you know that it's not a third-party vendor? Do you have a copy of it?
That's the point I was going to bring up here. You see in the additional protection insurance, which is the declination page, it says, see your extended service contract for details. Are we missing that document?
There is no extended service contract in the deal file that's presented to.
We don't know if it's a third party or not.
Is the preferred warranties phrase, is that a brand of warranty? Is that a warranty? Does that imply a warranty company? Is there any such company as that out there?
You can buy a 90-day extended warranty for probably $120, $25. It ain't going to cover a lot, but you can buy something like that for 90 days, and that's what this was a 90-day.
Powertrain warranty.
Yeah, so the third party is preferred warranties. Is that the interpretation of the commission?
We're missing a document.
Commission has no evidence to indicate that.
That's to my point. We don't know if it's third party or not, I don't think, unless.
We know that somebody that presented this warranty to the consumer went over the details of what the actual 30-day, 90-day.
We do not know if that happened or not.
That would be something that I would want to find out, because my F&I guy people, they disclose that all the time, what it covers. They give me copies of it. Covers, this is what it doesn't cover, transmission, engine, and all that. To me, that would play a key role in this.
They did make a $125 payment, right, for something?
They did give a $125 payment. I don't know if they actually received anything for it or not. I guess that's what they're disputing.
I would like to point out that there is a company called Preferred Warranties, Inc. that sells these types of plans. Because there was a question, I believe Chairman Roberts, you asked whether or not this is a company. There is a company out there. I don't know if it's this one, but like Matt said, there was nothing in the file that actually would indicate this is a copy of the contract.
Also, on the amount financed section, that 125 is listed under other charges, including amounts paid to others on your behalf. So I think having read that and seeing the logo down, that would imply a third-party warranty. That's who this dealer would send the 125 to.
It says two. Because right above it, it says two insurance company for credit life, two insurance company for credit disability premium, and then two preferred warranties.
Two preferred warranties.
Sounds like, yeah.
And the section under number 4 says paid to others on your behalf. So
So
I
that-
think that would imply
yeah,
a third-party
right,
warranty.
right. Okay.
So the complaint arises when the consumer goes to this dealer with what they feel is a claim and it was not paid, thereby the complaint. Where's the copy of the warranty and where's the?
We don't have any
I mean,
copy of the warranty. I'm looking through the response. Looks like they made a claim about the radio. They made a claim about a check engine light. Made a claim about a driver window having problems. Notified that there's a smell under the hood and the gas pedal was warm. Notified them that the brakes were squeaky.
Oh, none of those sound like complaints that would be covered under any type of a normal warranty. I think the problem arises is the consumer doesn't have a copy of the warranty coverages.
Right.
So, comes to a question, we wouldn't know this without some further investigation, but did the dealer send the 125 to this preferred insurance company, the third party? Which would be a big problem.
I think that's what we're struggling with. We don't know what the deceptive act is. Is this a paperwork error? Is this a mistake? Or did the dealer pocket this $125 and just claim that there's a warranty? And that's what we don't know. So I think maybe it needs to be recharacterized as to exactly what happened for us to determine if it is a deceptive act that we could agree with the proposed penalty.
Has the dealer been asked to produce paperwork other than what was apparently in the file?
Bill file that they've given us is all that we got from them. Looks like on June 2nd, they made a claim because the car wouldn't start. Vehicle would not start after talking with her on the phone, asking her to put the car in the on position, try to put the car in neutral. She could not get the car in neutral. We thought she had a dead battery.
Says she made a claim. Did she call the dealership or call the third ward?
This is where the dealership has on record of her contacting the dealership about issues with the car.
Do we know if this consumer took her car to another dealership who did the diagnose these items and then call the claim in? It could be that this particular dealership didn't have a service facility.
Chairman, can
Yes.
I address this?
Certainly.
It appears to me that we have a dealer that sold them a warranty and didn't give it to them, and clearly denied any claim on it, and they're just guilty as hell.
Well, I think that would be the deceptive act for us to deal with, and as Commissioner Levy mentioned, we have to determine, in some means, that in itself is a deceptive act, and did it occur?
A warranty here, they say service contract. What does that cover? That covers anything that could go wrong with a car.
If there is no term limit, then it's a warranty that goes with the car the whole time the consumer owns it. Now, that's why they're supposed to be called limited warranties and a term specified, whether it's 90 days or 2 years.
I don't believe they gave them a warranty. I think they
Well,
got the 100. There's no indication here that they did.
You know,
That's what we need to find out.
that's what, yeah, that would make this deliberation much simpler if we
The dealer
knew.
has had an opportunity to present that.
Mr. Reddish, could we call this consumer back and ask if, I think it was a she, has a copy of her warranty, if she were given that? I'm sorry.
Yes, we can call her.
Would that,
dealership to see if they have proof
And or
of
the
it.
dealership.
Or
Clearly,
both. I think
clearly
both.
missing a document
Yeah.
that's
Yeah, we-
illustrated in the paperwork.
I mean, I'd feel better about rendering a decision if we knew whether or not there actually was warranty. Now, we could, we can surmise from this that she didn't get one, if this is her entire file, and that's,
This is the dealer's file, as I understand
yeah.
it.
Well, I mean, is that it?
This
Is
is
that
the
it? Is
dealer's
it-
file. He's presented his case, and he didn't present any documents supporting that $125. And then he refused to do the repairs. He's guilty.
Well, apparently, we're looking for,
Commissioner Jackson. I agree with,
if the commission feels like this is the entirety of the presentation by the offending dealer, then I can see that.
and I agree with Commissioner Clayton over there because simply, if I'm gonna sell you a warranty, and there's nothing in the report that was presented to legal about when I came in and purchased that car, everything should have been in that file, including that preferred warranty. There's nothing in there that says the dealership informed the young lady that bought the car, this preferred warranty, you have to go here, or you have to do this, or you have to do that, nothing in there. So the dealership is obligated to say to that consumer, you buying a preferred warranty, we're not gonna cover it, but this is where you need to go. And the dealership didn't do that.
Coverage is.
Right, it didn't
Here's
do
a
that.
copy of your contract.
We're assuming. We're
Yeah, well-
assuming, there's a document missing.
Whereas,
Because I promise you, they sold a warranty to it.
If
well,
we-
the dealership should have prevented that document when they were notified about this incident, and they didn't present anything.
I mean, the commission can authorize me to try to settle the case for the $500, and I can ask them while I'm trying to settle it, hey, do you actually have a copy of this contract? And if they do, then we can just put it on for represent for close next meeting.
Well-
I mean, the decision we make's not necessarily
Let-
final.
That would
today.
clear a lot of.
Let me say this, though. This could be depending on how much we want to, what size bite we want to take out of this. If this dealer is habitually doing this, selling warranties, and not forwarding the money to the warranty company, we've got a really big case of deceit, fraud, and all kinds of things. And it would seem, yeah, we just go right ahead and fine them for deceptive acts on this case. We might be, for the sake of any other consumers, might have been harmed, because generally these things are a pattern. They're not generally a one-time occurrence. If a dealer's taking money for a service contract or extended warranty, they don't send it off to the third party to put that policy into force. What if there are 100 of these things out there?
Staff can open a complaint if we want a broader investigation. And we could open a separate complaint and just purely go in there and investigate them if we think there's evidence that they're doing that.
I think if they can't produce documents for this, then it would warrant going back in there. But I have seen it where somebody's done that before, where somebody forgot to send in the paperwork and there was a huge claim, and then it was, a insurance.
Yeah, it could
agent's
be a
errors and
clerical
omission.
error on a
Right.
one-time occasion,
Right.
but if this thing is a conspiracy,
I totally agree.
there could be 100 people out there that are, actually, that would lead to sending it to another agency, criminal investigation, if it got to that. But whatever the commission's appetite is for if you want to look for more, not to, we're not in the we're not in the business of expanding our cases. That might not be the case, but if we could ask for a sample, ask for this one, or ask for a sample, we might be doing the consumers a big favor.
Yeah, I believe that's possible.
More you could be doing the consumers a favor. If they're doing this, then obviously it doesn't go to a government agency, it goes to the dealer. As it
It looks as though the 125 was collected and should have been sent to preferred warranty. And maybe this is a one-time occurrence, a clerical error, but nonetheless, this consumer does not have a copy of a warranty, and that's bad right there in and of itself. But my concern is, are there more of these out there?
If you'll notice on the additional protection, there is no signature of the buyer on that.
Which pages,
On the,
Commissioner White?
it's the third page in,
Mhm.
additional protections and insurance, where it lists preferred warranties, $125. Stated, but there's no signature of the buyer.
Do you want to check the one? Here, I guess it gets to this maybe, not to guide the commission this way. Do we want to check out the one, or do we want to check out more?
I like Mr. Reddish's proposal that we authorize him to try to settle this amount by continuing to investigate the matter, and if additional evidence is shown to him, for a representation in January. And that's what I move for.
$500.
Yes.
All right.
There was
Second,
another
I'm
part-
sorry.
Let me pick up, it was seconded by Commissioner Galvin, but let's read it back, or restate it.
I make a motion to authorize the commission to attempt to settle this matter for the proposed $500. If additional evidence is presented during those settlement conferences that require the matter to be represented to the commission, that they do so in January for further discussion.
Here on the motion. It was seconded by Commissioner Galvin. Any discussion? Hearing none, chair calls for a roll call vote, and yes would be for the motion as indicated. Director Shaw?
Chairman Roberts,
Yes.
Commissioner Lee.
Yes.
Commissioner Galvin,
Yes.
Commissioner Clayton. Commissioner Fox.
Yes.
Commissioner Kramer. Commissioner Jackson. Commissioner Melton. Commissioner Murray. Commissioner Trickett.
Yes.
Commissioner Norton.
Yes.
Commissioner Parr.
No.
Commissioner Vaughn. Yes. Commissioner Tomaso.
Yes.
Commissioner Levy. Commissioner White.
Yes.
Commissioner Evans.
Yes.
Motion carries.
That would conclude the legal report, since there were two motions. I don't think we need a motion to approve the legal report. We've already done, we did the first
Yeah,
part.
I guess,
we've done the
we
second
already
part.
approved them, and then we have a roll call on that
So
one.
we can move on to legislative updates.
Would you like us to open a broader investigation into this dealership?
I think that was part of the motion. Was it?
If we find there's a violation, you would like a additional complaint opened?
Yes.
Okay.
Legislative updates.
Okay. We don't really have any legislative update because obviously they're not in session, but I did want to go ahead and brief everybody on, we had 4 rules that were posted to the Secretary of State. All 4 became effective between last meeting and this meeting. Those rules being, number 1, the cell phone rule, which basically gets rid of the requirement that a dealership have a landline. Second being the salvage rebuilt rule, which requires a dealership or salesperson who knowingly has a car that's salvaged, rebuilt, or has a salvage history must disclose on a form approved by the commission, inserted into the rule to the purchaser. We have the termination of dealership rules, which allows a franchise dealership who's being terminated to ask the commission to issue an order whether or not such termination would be fair. And then the surety bond rule, which just removed the motor vehicle commission as the beneficiary on our surety bond form. And I believe we have a change to the surety bond form that will need to get reapproved from the commission under old business.
Questions or comments? Get a motion to approve the legislative update. Is that, that's not a report, is that?
It's not a report, just.
Probably not
Just
necessary.
giving you
Okay.
update what's going on, so I don't think we need to approve anything.
Thing under new business. And old business, Director Shaw has a couple of items.
Under the old business, I would ask that legal address these issues after the passage of the temp tag fee schedule, which those of you who've been here for the past several meetings know that we've had quite a bit of discussion about that. After the passage, there were a few tweaks that legal recommended, and so I'm going to ask that they represent that as well as the language on the surety bond form. Matthew, if you could do that.
Sure. You should have the temporary tag log schedule uploaded on your iPad. Most of the changes we made were mostly grammatical, but I want to make sure everybody had a chance to review through this form, since this is going to be our official one. Probably end up on our website. Give everybody another chance to look through it. Asking questions if you had any. I know we have new members, so. Sure. So if you see on the bottom left corner here, this is one of the boxes we actually added. It said not binding. This policy is intended to serve as guidelines for the enforcement of the Tennessee Motor Vehicle Commission. Laws pertaining to temporary tags. Policy is not binding upon the commission when considering disciplinary action. So if we have a situation like that, we do have the discretion to not follow this temporary tag violation structure. So once they're issued a notice of violation, they'll have an opportunity to provide these facts to their inspector, and it should come back with the notice of violation to Paula and staff. So they'll have an opportunity to see their response, and I'll have an opportunity to see it, or Sarah. So, I mean, there's several people. They'll have the ability to pass on those additional facts if they'd like to, mitigating circumstances.
I'd like to also add to that, as some of you know, I used to be Director of Title and Registration for the state as well. And this fits hand in glove with policies. First of all, the issuance and the sale and distribution of all tags, including temporary tags, is governed by the Department of Revenue primarily. We do have some overlapping authority. The dealer has a temporary tag authority to issue the 2 30-day tags. Beyond that, the county clerks have the authority to issue a temporary operating permit, which you may have seen them from time to time. They're red. You'll see the green one is the one that you issue, minus the electronic ones that some of you are familiar with now because they're moving to that format. But the Department of Revenue also has a temporary operating permit, and it is intended for these situations. So to keep in our partnership and to keep consistent with the rules and laws of the Department of Revenue, that authority allows you and allows dealers to issue 2. If some extenuating circumstance arises, we would move to that TOP, which is the issuance of the TOP, because largely if we have gotten to a point where you've gone 60 days, we know occasionally a lien holder will lose a title. We know occasionally somebody signed it in the wrong place and it was a duplicate out of state. We know these things because we've experienced them. But there are more often than not, when you move beyond that 60-day time frame, there are circumstances that Department of Revenue needs to be made aware of. They do have enforcement division. They do have an investigative division that has authorities that we do not. So by moving it into the TOP process at that step of the transaction, either they have some abilities to help obtain titles from out-of-state jurisdictions that they may be having difficulties from, or there may be a situation that they themselves need to be looking into that is beyond what we're handling. And so many times what we deal with in a consumer fraud situation, unfortunately, is the circumstance where someone is basically holding the title to see if they pay enough money on it before they apply for a title. So in all situations, if it comes to me, I'm going to contact our partners at Department of Revenue and have them move immediately into approval of TOP. Because that is the process that's established in statute. Now, that doesn't mean, and I think that's what Matthew was explaining just a minute ago, there are some very limited situations where we can see that a dealer who has not had a previous history, it's a one-off situation, that we would want to consider those things, and I think that's what that statement is meant to address. But I would caution this commission, considering my background and experience, to be very cautious with that.
Comments? We don't hear any, so we can move on to the best part of the agenda, and that'd be adjournment.
We have to cover the surety bond. So actually,
Actually, we need to take a vote. We need to take a vote on
yeah,
that
we need to
amendment.
vote. We need to adopt the temporary tag log.
Second, by Commissioner Vaughn.
Not already done this, Commissioner Shaw? Temporary tag log? I
We
mean,
have-
the schedule, the fee schedule?
We have.
Fine schedule, excuse me, fine schedule.
We have adopted the fine schedule. It was based on the changes, and the reevaluation of the fee schedule was based on Chairman Faison coming to us last year. And so we worked quite extensively to put into place a graduated schedule that would consider those circumstances like we talked about, the previous history of the dealer and the impact on the consumer. We worked with legal on that and coordinated it. We passed it. And then after we got to the very end of that and passed it, I think legal gave it that one, let's go over it again. And they found some language that they thought would be beneficial to us, some grammatical and housekeeping type things that made some minor changes. And it was recommended by legal that we represent it to the commission to make sure that what is actually used and published is the actual document and language that the commission has approved.
So that requires
Another
approval
vote.
by the commission, another vote. All right, I think we had a motion. If somebody would tell me who the motions were made by.
The
Commissioner
motion was
Jackson?
made by Commissioner Jackson and seconded by Commissioner Vaughn.
Okay. Any discussion? Hearing none, those in favor of the action say yes.
Yes.
Those opposed say no. All right. Now, the surety bond.
Surety bond, this is actually the form we also approved previously. Staff asked that on the second page there where you see signature of principal, dealer, that we add a line, just a name of principal, so that we don't just have a signature, we have a print version, because sometimes we can't read the signatures. We want to know who actually signed it. So that's going to be the only change on that, but we need to have that approved.
I'd like to make a motion that we approve the new surety bond form.
Seconded, Commissioner Vaughn, seconded by Commissioner Lee. Discussion, hearing none, those in favor of the motion, surety bond form, say yes.
Yes.
Those opposed say no. Okay. Did I?
Now you can adjourn.
Council says we can adjourn. If we have a motion, we can do that.
Commissioner Jackson, motion that we adjourn.
Second.
We are adjourned. Thank you.
What is wrong with these things? We'll take a 10-minute break and then bring the Rules Committee together.
I'm Farrah Vaughn, the chairperson for the committee, and we have, actually, I'll let you do the roll call vote if you'd like, or I mean,
Thank you, Chairman. I will call the committee members by name. Please indicate by saying aye if you're present. Chairman Vaughn.
Aye.
Commissioner Lee. Commissioner Fox. Commissioner Murray. Commissioner White.
Aye.
We have a full committee. Yes, I do need to ask that we approve the agenda for the Rules Committee meeting. Oh, sorry. Give me just a second. We're getting this organized. This meeting date, time, and location have been noticed on the Tennessee Motor Vehicle Commission website, included as part of this year's meeting calendar since July 13, 2015. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission website since October 18, 2016. This meeting has also been noticed on the tn.gov website.
Have a motion to adopt the agenda.
I make a motion we adopt the agenda for today's meeting.
I'll second that. All in favor, say aye. Aye. Those opposed, say no.
Thank you.
Okay, now we can get started.
All right. Previously, at our last Rules Committee meeting, there were 3 items presented to the commission or to the committee for discussion and consideration of development of language for rule. And that information was provided to our legal staff, and they did come back with some recommendations. So I'm going to go through the process of just reading to catch everyone up, especially those who were not on the commission at that time. The analysis that was presented is the existing laws regarding applicants. This is item number 1, I'm sorry. The existing laws regarding applicants or entities who apply for licensure under a corporate structure are ambiguous as to the Commission's authority when one of the owners has previously been convicted of a crime of moral turpitude. The current statute or rules that were presented is in reference to TCA 55-17-114 and the promulgated rule 0960-01-.8. And the recommendation was to develop language to ensure the licensure process is fair for all individuals and to protect consuming public. The MVC staff was recommended that a rule be enacted which would allow the Commission the ability to deny an application if a manager, director, or owner of 5% interest or greater of the entity could be denied licensure as an individual pursuant to TCA 55-17-114 et al. Legal did develop language, recommended language. Matthew, would you like to speak to that, the recommended language?
Sure. Just as Paula basically read the rule that we drafted, the commission may deny an applicant for license if any manager, director, or owner of 5% interest or greater of the applicant could be denied licensure as an individual pursuant to TCA section 55-17-114. And as part of that, we're also going to change in the table of contents. Currently, 0960-01-.08 says dealer applications. So we're going to strike the word dealer, and that will make this apply to, for example, dismantle recyclers or other types of licensees. So this won't only apply to dealers. And the 5% number, currently on our dealer applications, we ask that dealers disclose any 5% or greater owner already. So this would just allow us to take those disclosed owners and see if they have any convictions for crimes of moral turpitude or other grounds that we can deny a salesperson on, and then apply it to the dealership. We've had a couple instances in the last year where we, basically the way we interpreted the law, we had to approve the dealership, but then we were telling the owner of the dealership she couldn't be a salesperson there because technically the applicant's an LLC and the LLC didn't have a felony on their record. So this would allow us to say, no, if one of your manager or directors or owners has a felony, we're going to impute that to the dealership and then have the authorization to deny your dealership application. The way that laws currently are, we actually did some research on this week. I mean, we possibly have the discretion to do it without this rule, but it would put us into some territory where we could possibly be opening ourselves up to lawsuit. So I think authority we need, and we'll make it broad enough to apply it to who we want to apply it to. Well, I think in particular, especially, I mean, a dealership could conceivably be publicly traded, and then you could buy one stock, and you'd be technically an owner of that company, and then we'd have to, it'd be, you can possibly see the situation there. We just went 5% because
It's consistent with what's already in
yeah.
statute. Because anyone who owns more than 5% in the application process, anyone who owns more than 5% of a dealership has to be identified in that application process. That's why it's consistent with the existing statute. And there was quite extensive, I don't know if Mr. Glendorf wants to add to this, but just this past week have done, Sarah Page actually, who's not in the room, has done some extensive research on this. And
I think Matt explained the idea of it very well. In kind of, I've had some historical background on it. I think Patrick Merkel even and I had discussions regarding this issue years ago or whatnot that has come up from time to time. But, you know, oddly enough, the way the statute reads it allows the commission broad rulemaking authority in order to see out the revisions of that chapter. And so what it does is it says, on part of your application, you have to tell us who the 5% owners are, even if it's a legal entity, a corporation, anything. And then it says at the beginning is that the commission has the ability to look at the character, the honesty, and the business relationships of the applicant. And then it goes on and says we can deny somebody an application if they had a crime involving moral turpitude. Well, the applicant, if it's a legal entity, is not going to be convicted of a crime. It would have been the previous owners. And we have a very specific statute that says if you were previously the owner or shareholder of a dealership and that dealership's license was revoked for cause, then you as a previous owner and individual could be denied a license. But it doesn't go so far as to say, oh, and you can't just skirt the law or the idea of it by just forming a legal entity under your own name. And so Sarah Page last week did some extensive research on this issue, and the end result is we believe that the commission does have discretion to deny those legal entities who have individual ownerships, whose the owners would have had certain violations under the statute, such as crimes involving moral turpitude. But what Matt's correct is I think that it really opens us up to potential litigation in that area if there was a denial. And so we believe that there's broad rulemaking authority, and we can just pass a rule that basically announces that. Then everybody would have given notice as to what this is, and going forward, and people can have comments on those if they would like. And the ultimate authority as to whether or not the commission has discretion will be the Attorney General's office as part of the review they have to do on any rules we send to them. It'll also be looked at by the Joint Government Operations Committee. They'll look at that rule and may make comment on it. But we believe that we do have the authority on that, and that'll help us go into the future so that if we have a really bad actor who has actually incorporated itself as a legal entity, that we can go ahead and say we have a very specific rule on this, and it's something that we can show them so that they haven't gone through the process of obtaining a dealership location with all of the overhead and all of the expense, thinking that this is something that is just easily done, and they don't have to look at or even worry about any kind of past transgressions that they may have had. So, questions on that? Okay.
Want to check for public comment?
Comments from the public? Nope.
If there's no question, I think, and this particular topic has previously been presented to this committee. So if the language is acceptable to this committee, what we would be looking for is a recommendation that the language be accepted and be presented in January to the full commission to accept for the rulemaking process to move forward.
Motion made by Commissioner Lee, seconded by Commissioner Fox. Do we need a roll call vote, or can it just be?
Everything with
Okay.
rulemaking.
Okay.
Chairman Vaughn.
Yes.
Commissioner Lee. Yes. Commissioner Fox.
Yes.
Commissioner Murray. Yes. Commissioner White. Yes. Motion carries. Chairman Roberts.
I think I am a voting member, so I'll vote
Chairman
yes.
Roberts. I'm sorry. Motion carries on that item. Item number 2. The previous analysis had to do with the inspection of business records. This issue was brought in regard to the inspection of business records. Currently, the Motor Vehicle Commission does not have an established rule which sets out the format for maintaining a temporary tag log, either in hard copy or electronically. The current statutes and rules, TCA 55-17-114, lowercase b, 1, 0, and the rule 0960-10-.11. The recommendation is to clarify the required format of maintaining a temporary tag log and to facilitate the inspection or investigation process. Staff recommends enactment of a rule stipulating that licensees maintain the required hard copy tag log in sequential order, recording them in the order in which they were issued, sold to another dealer, or voided. This rule shall not apply to any temporary tag or temporary tag log that is automatically generated from a state-operated system or database. This is recognizing that Department of Revenue is moving into an electronic issuance system, and that record would be maintained in a different format than would the reconciliation or the logging of the paper tags that are in a sequential number. And I will refer this to Matt to.
Sure. So the language legal is put together and proposes first sentence, so this would be Rule 0960-01-.11 under inspection of business records. First sentence would be licensees must maintain a record of all temporary tags acquired during the preceding 18 months. So I think we're envisioning this being the receipts they receive from the clerk when they pick up those tags to show what they purchased when the inspector comes out. Next sentence, all temporary tags shall be issued, sold to dealers, or voided in numerical order within the sequence they were received. So this is basically, I think we covered the ways you can dispose of a tag. So however that tag moves out of your possession or becomes voided, you basically re-record that in the numerical order that the tag is entered. What will happen a lot of times, especially with our new temporary tag log fee schedule, if the inspector goes out there and a dealership's jumping all around, pulling tags out of the middle, and they have no real order, for all practical purposes, it's impossible for that inspector to go out there and audit that temporary tag log without sitting down and spending several hours trying to put it into order themselves. So we're going to ask that the dealerships basically issue those tags in order. Next sentence, all temporary tags shall be recorded in a temporary tag log in the order which they were issued, sold to another dealer, or voided. This rule shall not apply to any temporary tag or temporary tag log that is automatically generated from state-operated system or database. As Paula mentioned, this is taking into account that Revenue is trying to roll out a system where everything will be done online, in which case, basically, your temporary tag logs will be kept by a state database.
Any discussion? Comments from the audience?
Have, I guess, some rhetorical questions. Patrick Merkel, I'm with the law firm of Cameron Worley in Brentwood. And I guess, I think there are some that are doing, this is requiring handwritten as opposed to Excel sheets. So I don't know if anybody is doing electronic requirements. I haven't seen the language, but from the description, it sounds like you're doing away with the electronic keeping of that. I've sat in Mr. Reddish's seat. I've sat before you or representing dealers. If they specifically require to be in order, you're gonna end up having a lot of complaints filed solely because they have to be in order. And if they're out of order just one, you flip some numbers and make a mistake, that's a violation of the rule. I understand what Mr. Reddish is saying and the commission is saying, but there's a lot of requirements being shoved back on the dealer's staff to make sure that they're kept in order, as opposed to pulling out ones out of the drawer and recording them as they go. I just wanted to make sure that those points were brought up. I think that having specific requirements are fine. When I said to Mr. Reddish, we always told people, do what's required by the Department of Revenue. The Revenue's got a form that you can fill out. If you fill out the form, that was sufficient. I'm not positive that this is I think you could be opening a box that creates more problems. I just wanted to raise that issue.
Investigator goes in to check them. Is he using the Department of Revenue log, or is he using, I mean, I've seen it in our own stores. We got hand helter-skelter. There's not really a great system I've seen. Maybe there is.
Oh, so what my experience, and I think I've showed this to Matt and Jason, and I had done this in the past, is that first, if I could, I'd like to point out to Mr. Merkel's comment about not having electronic records, is that electronic records, we're not actually amending that rule. That's currently still listed under 0960.01.11, which is 2. So that's
yeah,
so
right. But I thought that
written or electronic.
I thought he said that they had to be handwritten.
It doesn't say handwritten. It says all temporary tags shall be recorded in a temporary tag log in the order which they were issued, sold to another dealer, or voided. So it just says recorded in a temporary tag log.
Then I apologize, because that was my mistake. I did not have the hard copy. So
No, I understand. I just wanted to clarify that it still allows you to have it in electronic format. So to your question, is that we do have the capability when we do inspections is to determine how many temporary tags they purchased within a certain period of time. When that inspector goes in there, the worst case scenario for our inspectors is they go in there and there's a temporary tag log that's almost an inch thick, and they're not in one way or the other. And then they just they'll just take a view of it and say, oh, well, you've issued 3 here, you've issued 3 here. And so then they send it over to the Motor Vehicle Commission and say, well, there's a violation. And in the past, I believe Jason has and myself has gone through there and taken every last 4 digits of a temporary tag, put them in an Excel spreadsheet ourselves, and then come in and then put in like the last name or the name of the person or last 4 of the VIN. And then through a spreadsheet, we found that we started matching things up where they would have issued more than 2 temporary tags on maybe, could have been 50 times. But you couldn't see that on a 1-inch document. You would just see. So then we had a bigger problem, and it was a lot of work on the staff to do that. When we had just these really large temporary tags, logs come in, and we thought, well, they're issued out in sequential numbers. So if you buy 200, they're issued out in sequential numbers. We didn't think it comes in a packet. How difficult is it just to know how many you did, and then you just issue them out and record them in order as to how you purchase them, so that we can look at that, because we think that not having them in numerical order opens up it's very easy for somebody to hide temporary tags that have been issued down in there when they don't have them in order. And when we looked at this, as a group, we thought that if they started the practice correct of putting them in order, that it wouldn't be an overly burdensome administrative process. But I do understand that if they don't do the administrative process of putting them in order, then it just would be a technical violation. And then the commission could do, multiple different ways of determining what is appropriate penalty for that.
Here's a real world situation that I see, because if we've got them, we keep them in the safe. We've got our office manager gives them to the F&I department, so she logs them. Saturdays, I'm there. I go in the safe. I get them. We're out of temporary tags. They've got 3 packets of them in there. What is there, 50 or 100 a piece in there? I don't know what it is. Pretty. I reach out the wrong one. Don't give it, and I take it, give it to F&I. They start giving them out. It's not in order, so there it becomes a violation. I think it could be easily explained, but your investigators, it would depend upon how much flexibility.
If I could speak to this, because I spent 9 years checking these things out in the field, and I know basically from the Department of Revenue codes, they tell you, as far as their rules and regulations, they will tell you what information is to be collected on each tag that you sell. The form that they use is a recommended format, because way back when, they recognized that the dealers had trouble recording these, and they tried to come up with a standardized format. As technology evolved over the years, they were allowed, many dealers, and I know some of the commission members that are sitting up here, I have actually checked their logs in the past, and they maintain theirs in a Excel spreadsheet. But they had all of the required information. And to speak to Mr. Merkel's point, I think he's very wise in breaking the point that he did, so that you don't end up with technical violations, because that's the very thing that we're trying to guard against. Because the situations that you're describing, Commissioner Lee, happen. You see it every day when you're working in the field, because you've got a salesperson that comes in and grabs it out of the stack. But there's also an accounting and a reconciliation back to that receipt where a hard copy tag was purchased. And what we're seeking to do is to be able to avoid those types of situations. I have seen those types of situations occur where people have been cited that and accidentally. And then when we went back and reconciled the logs, that we could see that it was strictly because they were not in numeric order. And those that I worked with over the years that are familiar with me, we worked out a thing a long time ago where this was actually, it was handled this way. They log them in because they come out in sequential number, and even if it gets pulled, the person who's responsible for maintaining that log will go back for the accounting and go, where's this tag? Which salesperson drug this out on Saturday, and enter it back in the log. Part of it goes back to logging it in when you purchase it, that sequence, and you will know most of the time. Sometimes an accident will happen, and we recognize that. But I think this will address some of the technical concerns that Mr. Merkel, that you were presenting, that you were bringing up. And we also wanted to include in this rule, recognizing that the electronic process that Department of Revenue is moving to, they will not be in that sequential format, because the format that they're moving to is pulling from one statewide table database. So you could have one tag number pulled in Mountain City and another tag number pulled in Memphis within a matter of minutes. So if we don't address this by rule, those technical considerations that Mr. Merkel presented, I think we're leaving the door open for it to become more confusing as time goes on.
I think the situation you described is when I think you finish one stack and then you go to the next stack. Maybe you don't get them in the order they came from the clerk. So the rule says all temporary tags shall be issued, sold to dealers, or voided in numerical order within the sequence they were received. So it doesn't actually require that you use the stacks in the order you received them from the clerk. Sure, I think as long as you stay within one, if you got a stack in January and a stack in February and you accidentally start the February stack, as long as you're not doing like February, January, I don't think that would be a violation under this rule, as long as you stay within the packet that you open.
And ultimately, it should reconcile to the receipt from where you purchased the tags from Department of Revenue. That's ultimately what should happen.
So what you're saying is you're tabling that temporary tag to
Any vehicle that's sold from a licensed dealer in the state of Tennessee would, if you put a temporary tag on it, a state of Tennessee temporary tag on it, should be recorded in that log. If it's voided, if your person that was, or the sale didn't materialize, you're gonna have that tag in the book. I mean, these things are already in the rule. You would have that tag in your manual log, if that be the case, and you would have voided written across, and that would reconcile all back to the tag, the transaction, all of it would match back up. And when we have those things where we have some discrepancies, some people are better bookkeepers than others, and so when we have these things clarified, it helps ease the process for the dealer, truthfully, in the long run, and for the person that's inspecting them or investigating them, so they can get in and get out of your business, you know, at a much faster pace, that rather than sitting there and going through logs and asking you questions and having you pull deal files all over the place.
With my, I guess some of the experience that I've had with rolling out new rules and how you actually enforce those is the commission can enforce them how it wants, you know, so it doesn't have to be a strict, you know, if they say, you know, temporary tag logs have to be, they have to be in sequential order, the commission could do multiple things that it wanted to, because when I think of these things, I understand both sides of the issue, and really it's not an issue if everybody actually complied and did this. So if we said, oh, it's a requirement, the commission could do several things. It could say, for the first year for the enforcement of this, we're just going to issue a letter of warnings, and just let the information get out there so that everybody gets used to doing this or whatnot, you know. And then if it's really, you know, bad, we'll just keep on doing what we want. So you could actually delay any actual disciplinary action for a period of time, 6 months. It wouldn't matter really. You could also do something, whereas if you didn't want to do that, you could do a lesser civil penalty amount for these type of violations, just because you would kind of recognize and understand that this is a new rule and it's a new requirement, and to get and maybe they're just not up on the actual information on how to comply, that you could have like a kind of a period where there's a transition or whatnot. So I've seen those done in other programs in the past, and it's been very, very helpful, where you can do the public outreach and kind of give them that information.
Do you know how long roughly before everybody's online issuing temporary tags? If there's a goal?
I don't think that they have a timeline, because they recognize from the last communications that I had with them, and anytime you deploy a statewide technology system, there's a ramp-up period, and there's early adopters, and then there are individuals who may not have access to online capability. And we don't have a requirement, even in our rules, that you would have web access and a computer in your office. That's not part of your required equipment to obtain a license in the state of Tennessee. So I foresee some early adopters, a ramp-up period for quite some time, and then I don't think that, and I can't speak for Department of Revenue, but I don't think they have put a firm, everyone will be online by this time. I'm not aware of that they have. So we need to, in that regard, that's the thing that concerns me for our field staff, is there's going to be a considerable period of time where individuals may be using both. They may use paper tags, and they may use electronic tags, both at different locations while they're bringing, if they got multiple locations, or for different purposes. So
also think about, you know, if your computer system's down, the last thing you want to do is go, you're going to have to wait.
Absolutely.
So I can see the need for both, to be perfectly honest.
I'll second it.
A roll call vote, please.
Chairman Vaughn,
Yes.
Commissioner Lee? Commissioner Fox? Commissioner Murray? Commissioner White? Chairman Roberts? Motion carries. Thank you. Item 3. This one is a little bit tricky. It is a result, or it's being presented as a result of a statute that passed last year. And it's probably easiest just to read it to you. The analysis, MVC staff, and the Enforcement Division are currently experiencing challenges regarding licensure during the inspection process related to entities who seek to operate an additional business type from their location. This challenge resulted following the passage of a recently enacted legislation which allows the dealer principal to operate at least one additional business from their established place of business. I think everyone on the committee is aware of the fact that prior to the passage of that legislation, the rules and laws of the Motor Vehicle Commission only permitted one business to be operated from an established place of business. Last session, I believe I'm quoting that properly, a statute was passed that allowed a dealer principal to operate one additional business from their established location. However, no rules were further information was provided on how to distinguish the records. And I'm gonna, because this gets really technical from a legal standpoint about the, it's just like a 66-33 split, and it regards the, I'm gonna say the footprint of the establishment and the financial aspects of the business. So this rule, this consideration for rule is being, had been presented to bring some clarity to that. And with that, I'm just gonna hand this off to Matt and let him read the language that was drafted for the committee's consideration.
So this is really another rule that makes it possible for us to actually enforce the statute. As Paul is talking about, the statute 5517-129 states that you can have a second business, but it can't be more than, just paraphrasing, can't be more than 33% of the ground space of the building, and it can't be more than 33% of the profits. The dealership has to be 66% of, yeah, it's kind of weird how they worded it. But yeah, gross sales have to be like 66% based on the dealership's primary business as a motor vehicle dealer. So what we ran into is our inspectors can go out there, as far as the ground space, I mean, they can pull out their tape measure and get an idea of the rough square footage of each part of the business, but it's really difficult to try to go through all their business records and determine, all right, how much money did you make from running a Subway here, and how much money did you make from running a car dealership? So what this rule is going to do is require them to keep the business records for those two businesses in separate locations. So read the language of the rule. All motor vehicle or recreational vehicle dealers who are operating an additional business at the dealership in accordance with TCA 5517-129 shall maintain each such business's records and inventory, including sales and use tax records, in a clearly marked and separate location apart from the motor vehicle or recreational vehicle dealership's records and inventory. Hopefully what this is going to allow is when the inspector goes in there, they can say, no, I want to see your sales and use tax records for this business. I want to see them for this one, and they should be able to add it up and say, no, you're within this 66-33 framework.
And the other aspect of that is if there's no clarity in maintaining the records or the inventory separately, you may have whatever the other type of business is, you've got the records mixed together, all in one location. So there's always that risk that you are looking at a record that you don't really have the authority to look at if they're not maintained separately. If whatever, there's the dealership, and then there's business B, and if they're all commingled, for lack of a better word, but if they're all mixed together, you have the risk of pulling out a file to look at, even though they say, oh, my records are in this drawer. You could be accessing, or the commission staff or field people could be accessing a record that they don't have regulatory authority to look at, which is a potential risk for us.
Comment from the audience? Okay.
The way the current law reads is that the business, both businesses have to be owned by the dealer principal. So it could not be Paula Shaw and Jason Gillum own two businesses in this establishment. It would have to be Corin White own both businesses within that established place of business.
They're separate.
Or LLC.
So there's separate LLCs, or can it be one umbrella with two divisions of a business?
I believe it has to be under one umbrella of a business. We have separate rules if you want to have, if you have like two separate businesses operating there and you want to put up a dividing wall, and like we have a lot of rules that go into that situation where like if it's just one building and then you have like a little restaurant and you have a dealership, I mean, you can put up a dividing wall with no, I think it's like no entrance in between them, and the dealership has to still have a bathroom and all these other requirements. What this is envisioning, if you just have one large building and your dealership is selling cars, and then they're also, we've seen where basically they're running like a little flea market there. They're selling like machetes and discount knives and stuff like that over in the corner. But it's all those records are being kept in the same place.
Right, or there's possibly issues in the past where you had what looked more like a store that was selling cars on the side. So exactly, there was a complaint. I think we had several of those type of complaints years ago where it was an auto detail place that also sold vehicles on the side. So the way that this statute that was passed, 5517-129, said, okay, you can have another. It says the motor vehicle dealer can have an additional business. It doesn't go into detail as to who owns it. It doesn't go into detail as it has to be a separate entity or whatnot. That's really up for the Motor Vehicle Commission to decide. Kind of here with kind of the idea of passing this rule, or how are we going to regulate that? And then it says, you know, part of that is that the percentages is that at least 66% of the location has to be for the dealership, and then no more than 1/3 of the gross income can be from the additional business. So it has to primarily be a motor vehicle dealership is generally what it is. So we can easily go in, and it's a point of contention when we have inspectors go in, is because this statute is here, we're required to regulate it, and they don't know how to they're having difficulty making a determination as to whether or not they're complying with the statute. And so they can easily say, okay, well, 66% of this actual physical space is the motor vehicle dealership. I've got that, you know. But what's difficult to determine is what percentage is your additional business. What is that additional revenue, so that we can go in there? Because if we have an issue that arises, and say we have, and this is just the example that you gave, say you had an auto wash place that was also selling motor vehicles on the side, let's just say on the side, but it didn't make up 33. Let's just say the car detail place made up, we suspected, a lot more of the gross income than the dealership did, and say we had issues with the dealership, ancillary issues, and this is why we're looking at them. It would be extremely difficult for us to prove what percentage of the gross income that the auto wash had as opposed to the dealership if they have one set of books. Even if they didn't keep books, nothing says they have to keep these books or whatnot. So we're trying to create this rule, or else we can't enforce it. If we don't have a requirement to have some kind of way of how you set your books out for us to look at, then we actually can't enforce the provision of this statute, and it really doesn't do much at that point in time. So what we're just trying to do is create those minimum requirements, and in speaking with Director Shaw and whatnot, and her experience in the past, and then kind of what we've seen is try to set up what are those guidelines. So here they would have to have separate The way that we look at it, the way the rule is written is that you have to have separate tax records, which indicates a separate, two separate books that you would have for each of these businesses in the dealership. Yes, that's what the
Not
rule
just
says here.
separate bank accounts or operational accounts.
I mean, this rule says actual tax records. That's correct. I mean, that's how you guys read it. Mm-hmm.
Sales and use tax records.
It'd have to be a separate entity then.
That's kind of how I read it now. Right. Now, I mean, if you all, I mean, I'm not really sure what your all comments would be on that or whatnot, but that's just how we wrote it when we envisioned it.
Well, and that's what you're stumbling on is to some of the
Smaller,
some of the dilemmas that the field people are running into at this time. Up until this particular statute passed, we had a exemption that many of our dealers fell under, which was incidental there too. There's a lot of things that are incidental there too, and I think it might help to read the actual statute to show you the dilemma that we're facing now. Matthew, if you don't mind.
Statute 5517-129, operation of other business at dealer's established place of business, states a motor vehicle dealer licensed to sell motor vehicles may operate one additional business at the dealer's established place of business, provided at least 66% of the dealer's established place of business is used for the sale or service or both of motor vehicles, and that the income derived from the additional business is less than 33% of the gross income of the dealership. The dealer may also install signs at the dealer's established place of business for the purpose of advertising the other businesses.
I think the question gets to is business license, definition of a business, is it,
So there's no requirement that they have two separate entities for the two businesses. I don't think we could require them to. I think that might be going outside what the statute allows.
Other than, I mean, well, that's what our rule says. It says including sales. It says shall maintain each business's records and inventory, including sales and tax records.
But I mean, like, they have to have like two LLCs.
Well, that's what, I mean, that's what, I mean, Ms.
That's what I
Schaefer's saying.
that's the
Essentially,
question.
that's what you've done. That's what we've done, whether it's, right, if it's intentional or not.
If they could have separate bank accounts where they roll up everything through separate accounts, I mean, they can still maintain the same records.
Right.
Separate accounting records.
Right,
So-
yeah. You don't need a separate business. You could have a division within your umbrella.
Right. So,
I'm also, I guess, cloudy a little bit about the property division versus the revenue division.
it's two requirements. It actually is. I mean, you have to have,
Separate. You
the
gotta have
physical space has to be.
66% of property and 66% of revenue or more has to be under.
There are actually three components in this, which you can imagine being an enforcement person and trying to sort through this. The dealer principal, whomever the dealer principal is, has to own both businesses. The majority of the business has to be auto sales, which is 66%. And I think that was the business records or the gross receipts are the majority of the sales for that particular business. So there's three components. The question is, and the challenge that we are experiencing is how do you establish that when you go in from a regulatory standpoint? So the field folks are continually coming back going, well, how are we supposed to know? How are we supposed to check this? And so whatever rule, if the language in this rule is not acceptable to this committee, or you think you feel like it needs additional work, that's fine. But the problem still exists out there for the field staff to be able to make those determinations, because we all know that, businesses have to survive, and they're going to branch over, especially in some of the more rural areas. Sales are good at part of the year, and other parts of the year the auto sales may not be as good, so you're going to branch over into other things. I think the issue that really gave rise to this had to do with the sale of sheds and other types of products. Now, since this rule has passed, we are seeing an expansion of other types of businesses that want to come in and under the same umbrella with an auto sale. So all of that stuff that would have been incidental there too, or regional, in some parts of the state where camping is prevalent, you'll see more camping-related items, or where water sports, you'll see more water sports-related items that may be traded in. Shelbyville, I'll mention because I worked it for so long, horse trailers. You'll see those things. But now it's branching out into a whole different arena. Absolutely, absolutely. So if this language does not make this body comfortable at this point in time, we can always take it back. It's still in committee, and tweak it some more if there are any recommendations.
My suggestion would be that you do take it back, because if it's hard for us to understand, it's going to be hard for other people to understand, and you don't want to take the entrepreneurial spirit away from the person that's trying to do that business, but I think it needs to be clarified.
Why, I'm sorry.
Go ahead, I'm sorry.
Why the division of the property
This is the law that passed by the legislature. That's what's driven this. It wasn't a commission-driven change. I think it was in consideration of the need or the ability for a licensee to add other products. I think that's the case. And Chairman, you may be able, you've got some history on this, you may be able to add some information or history to this. Okay.
And I think I don't know the intent of why they passed that actual statute, but because they put a percentage on it, 66%, so mainly most of the space is for the dealership and most of the income drive is for the dealership, that would have to be in there, even if the legislature wanted an additional business to be in there. That type language has to be in there in order for the legislature to maintain basically the basic understanding of a dealership, which is a dealership is required to have an established place of business, which is a defined term, and it's a place in which is primarily used for the sale of motor vehicles. So since its inception, a motor vehicle dealer law has been that a motor vehicle dealership has to primarily be used for motor vehicle dealership business, that it is not something that is ancillary to another business. And that's also why they have to maintain certain hours as far as a dealership is concerned. So it's required to maintain certain hours to maintain that established place of business or whatnot, so that it's permanent. So that's likely why that is in there. But we can definitely go back and look at this.
I'm not offering this as a solution, but as a train of thought. And I think that right question. In the recommendations, as it says, should maintain each such business's record, and business is possessive. So that means each business would have its own record. But if we were to think in terms of each business entity, and I'm not encouraging the word entity be inserted necessarily, but it seems that we're talking about entities versus entities based with two different revenue streams, if you will, versus one entity with combined revenue streams. And does trying to get us off the dime on this? Does it help at all?
I think so. I mean, I just don't think this is such a complicated statute and such a complicated scenario. I'm not sure there's ever going to be, I shouldn't say ever, it's going to be extremely difficult to come up with something that's not confusing as a way to enforce this.
What the statute's trying to do is to match the revenue to the space allocation of the two businesses. And there could be one set of books, but yet you have journals for inventory of shoes and one journal inventory vehicles. And that kind of gets to the question: do we just have to maintain a inventory of two different inventories, where you could actually go in and count the inventory, but yet the statute intent is for 66% of the business to be measured, not necessarily 66% of the
The gross receipts, gross sales, and that's where the challenge comes in.
Because you could have a service business in an
Yeah,
Well,
it's-
and I
it's-
think there's room, you know, and that's, I think there's room for us to look at this particular rule. The drafted language, and let me read it to you, and I think where you're focusing on, Commissioner White, is the, including sales and use tax records. I think that's the part that caught your attention. So, all motor vehicle or recreational vehicle dealers who are operating an additional business at the established dealership in accordance with TCA 55-17109 shall maintain each such business records and inventory, and just possibly remove that part where it says including sales and use tax records in a clearly marked and separated location apart from the motor vehicle or recreational vehicle dealership records and inventory. That would take that concern out of the mix, and at this point, add some clarity for the field staff who are going in there, because this problem exists now. So, and I'm, you know, I would think that we may have to revisit this later on as other things come up, but it would offer some clarity, at least in the initial part, that wouldn't be overly burdensome. So,
That's actually exactly what I was thinking as well. If there's some way to add something in there that's, because my concern too was if I had two separate businesses, I mean, I probably would have two separate entities, but at the same time, I'm not sure everybody would. And the tax records were definitely my concern as well.
How far do we want to go?
Yeah.
How far does the commission want to go? Does it wish to loosen the structure, loosen our statutes a little, allow for two businesses inside of the same structure, or do we intend to just together? I don't know that we need to go all the way toward one set of books and one inventory. I mean, you could, the commingling of
I agree with that
these
totally.
things is just get to be, you know, look at it as two separate business entities. Yeah, you can.
I've seen this in
Well,
years past.
yeah.
I mean, I'll just offer this as experience going in as a field agent, where you had businesses that, actually, that was when it's one established place of business, and you can get in some really tricky situations where there's a separate business in there. If you even touch a file that's not part of that business, they, at that point in time, they may have been in violation because they had a separate business in there. Nonetheless, you still got all kinds of problems. So I can, for those people who are trying to operate properly, and for the field people that don't want to overly burden or interrupt or disrupt a business out there, some clarity, we do need to add some clarity here for them.
With that in mind, why don't we just require a sales tax report showing that 2/3 of the sales and the sales tax remitted to the state comes from the automobile side, and the other side is no more than 30.
I'm gonna look to
we're kinda
legal
getting-
to address
you know,
that.
to
I
me-
think we're probably gonna have to take this back and work on the language.
To me, if we're inventory, you know, we're getting into a full set of books, and when you get into a full set of books like that, it should be separate entities. You know, our field investigators don't have the authority to check inventory, I don't think, or would want to. Why not just look at the sales tax returns? Does that match the statute if we just do a sales tax returns?
Well, I think there would have to be some kind of separation when you actually do those sales tax returns, and I mean, and I do understand.
Yeah, without a doubt, two separate sales tax
Right, you would have
returns.
to, and that is, I mean, here's part of my looking into the future. If we do have that and we go in front of the Joint Government Operations Committee, and I have to explain as to why we're about to have two different sets of books for tax purposes, I don't know what that cost is, right? I don't know what that cost per dealership is. I don't even know how many dealerships actually would have a separate business. But to be able to justify that, I would have to, we would need to look at and say, what is that actual cost to, or what is the average cost for a location to do that? So So I understand that, I absolutely understand that point, but I understand the concern is whether or not it would be overly burdensome. And I was just sitting here and it just kind of, and you mentioned it, but I just kind of thought about it, and I haven't even talked to Ms. Shaw about it because it's just thought. Well, I mean, what if the dealerships that had separate business entities were required to just provide a report to the Motor Vehicle Commission on a yearly basis or whatnot that indicated what its gross sales were for the dealership and then for the ancillary business, and that's a record that we keep. And I don't even know if that's a good idea, but it's just an idea that I just thought of when we were talking about other ways of looking at this. Of course, it'd have to be substantiated one way or the other. I mean, if you provide a report.
But if you go further than that report that you mentioned with the gross sales reported, any further than that, it almost requires a separate entity. Well, I mean, it would be, I think for accuracy's sake for the owner, well, I guess I'm looking at it as if I own the business. I wouldn't want all those things commingled. I'm not sure we need to think about inventory.
I think inventory is partially the area concerns, like a shelf. It could be like really hard to measure that out unless like you kind of have like your separate business blocked off a little bit. When we brought the case to you before, it looked like they're running some kind of market in there. Like they'd have like license plates, and the next row was something not related, and then they could have another row with like mufflers or something they could argue was kind of motor vehicle related. So I think that's kind of where we get the inventory idea, that we need to be able to go in there with a measuring tape and say like, okay, this is how much area you actually have assigned to dealership, and this is how much you have assigned to your thrift shop.
Well, it makes sense because you could technically say that's a parts department.
Which is true, because you can have anything that's motor vehicle
That would be
accessories, parts, or
incidental.
service would actually be part of that dealership.
You would walk
We
past that
currently do
anyway. That would be incidental there too.
But I think you could have like Cheetos on one aisle and then parts, and then you're back to
Those mufflers,
10 pocket knives for $1 on the next aisle.
Right. So
Sounds like the worst store ever.
it's kind of right. It's kind of joking, but it is. So the 33%. So the percentage is actually the gross income percentage. So it's the dealership has to have a 66% of the gross income of dealership.
Gross income.
Right. Well, it's actually 67%. I mean, it seems like you could have an accounting where all of your ancillary other inventory has like a different code, like it's coded differently.
Yeah, you can do that.
You could have two separate bank accounts. You could have a separate code so that every time you ring this up, you know it's a certain code, and you just said, well, the gross income derived from this is that amount. I mean, so I think, what we were trying to do is we were trying to make it so that there was some kind of an accounting record of it, because we have to enforce the statute, but we were absolutely concerned that it could be so overly burdensome as to what we're doing, that we kind of recognize that we didn't want to.
It's my opinion that having separate entities and separate tax returns would be overly burdensome for a small business.
That's basically addressing that little clause in the statute that we referenced where it says maintaining separate taxes.
Right.
Separate taxes. And the statute does specifically address
If it's specifically
vehicles that the income, let me read it again. A motor vehicle dealer licensed to sell motor vehicles may operate one additional business at the dealer's established place of business, provided at least 60% of the dealer's established place of business is used for the sales or service or both of motor vehicles, and that the income derived from the additional business is less than 33% of the gross income of the dealership. The dealer may also install signs at the dealer's established place of business for the purpose of advertising the other businesses. Some may be corporate, some may be sole proprietorship. That didn't say that part, that was my caveat.
The commission wants to recognize Daryl Noble.
Daryl Noble, Executive Director of the Tennessee Auto Dealer Association. I know where this bill stemmed from. I wasn't for it at the time because I figured we'd end up in a place like this, but now that we have it, I've got 3 or 4 companies of my own, and we have a company that we line item our stuff. You're not going to be able to put these guys on separate checking accounts and separate DBAs and all of that. A lot of them are just DBAs. But when they're doing their automotive sales tax return, that's taxed at a different rate than accessories and anything else. It's going to show up on their tax return. So what I think you'd want to require is to see the tax returns for verification. Because the verification would say, okay, I sold $1 million in cars, and I sold $200,000 in whatever else that I was selling. And that's going to give you your ratio right there. The state's not going to allow them to pay a lower sales tax by rolling it into inventory because they have to report the inventory. And as far as 66% of inventory of the facility being used, the inspectors can see that. They can walk in and say, hey, you know, the majority of this place is taken up by your automobiles, and you got this little corner over here selling whatever it is that you're selling. Now, if they go in and it's in the opposite direction, they're already in violation at that point. But a sales tax return from the previous months, however they want to go back, they're reporting that on the 20th of the month of every month, so they'll have that every single month. You're not going to have a report that's over 30 days. They're going to have that. But to tell them that they've got to have a separate, you know, checking account, a separate DBA, and all of this, it's just not going to happen. Because I know, like I said, where this thing stemmed from, and when Representative Pody brought it to me, I told him, I said, we're going to have some major issues with this, trying to track this. And I sat in on the bill when we're trying to do the 3366, and I said, okay, so let's just think about this. As Commissioner White said earlier, there's times of the year that some businesses are better than the others. So when we get down to where this thing is 50-50 and we're in a very rural county, who do you think they're going to call when we find them, or you guys find them? Their state representative, and he's going to jump right on the bandwagon and say, hey, we can't stop people from making money, because we've been down that road too. So I think we just try to balance it a little bit and just bring it back to sales tax and visual look of what does your lot look like. So
Why was the bill
I mean,
passed to start with?
Huh?
The bill.
Why was it passed?
Yeah, why did they, what was it before? 100%?
100%. You had to have automotive only. You know, when I say automotive only, you know, if you were a franchise dealer or even a used car dealer, you could sell tires and automotive accessories and things like that, like everybody does. These people here, this dealer was in Cannon County, and they were selling carports and wooden buildings, and the state come in and shut them down. You know, I mean, they literally said they fined them and shut them down, and that dealer and that state representative showed up in my office and said, why can't we do this? And I said, this is why. You know, I'm trying to keep the automotive industry as automotive as I can, but I also told them when we open this up to everything, we're opening it to everything. You know, you can have a pornographic shop at your dealership, you can have a strip club, you could sell marijuana when it becomes legal. All these things will come into play. I said, let's broaden it a little bit, put stipulations and keep it automotive, but it didn't happen that way. So, but if you take this and just, you know, line item it with your sales tax report, no matter whether it's a separate entity or not, you're going to be able to find out what type of business that guy's doing. Because a lot of people run all their cash into one account anyway, so that's irrelevant to the situation. The sales tax has got to be line item.
Given its line item, what kind of presentation would there be to an investigator coming in? Are you physically going to separate those on spreadsheets? I mean, how's it reported?
It'll be under
reported to revenue? Does it go into revenue as this is car? If it's blended all together in one sales tax report, that would require someone to sit down and check this off.
Whoever's doing your sales tax is going to have to do that, Commissioner Roberts. I'm sure you guys do it at your dealerships.
I understand the line items, but I mean just separating them out physically.
I'm sure at the dealerships when you guys are paying sales tax.
Well, are they submitted that way though?
Yes, they are. Okay. You say this is how much we paid in automotive, okay, because that's taxed at a different rate, and I'm sure you guys are doing it, and this is what we sold in the parts and service, all right, and this is what our tax rate is over here, because it's a little bit higher tax rate. So that's going to balance that out.
For inspection purposes, how is it presented to an inspector that wants to establish?
He just has to look at the tax return, and it'll
I mean,
show.
Is it on, or I don't mean to be simple-minded.
No, it's okay.
Are they on separate pages and with a
But there's two sides to the tax return, and the tax return is a little bit different too. It's kind of like temp tags. We can do it manually or we can do it electronically.
Well, I mean, at a glance, can an inspector look at?
He should be able to,
and
because he'll say.
Okay, this much is,
Yes.
vehicle
It'll say
sales
automotive
tax, and
sales.
This is for the other business.
It'll say automotive sales, wholesale sales, and then other. And then they'll put in whatever that other was, whatever that business is.
Well, it wouldn't require a separate entity.
Doesn't
to
require a
separate out the
separate
sales
entity.
tax.
Make a motion that we send this back to legal to reword.
Thank you.
Roll call vote, please. Chairman Vaughn?
Yes.
Commissioner Lee?
Yes.
Commissioner Fox?
Yes.
Commissioner Murray?
Yes.
Commissioner White? Chairman Roberts?
Yes.
Motion carries.
Are we on to new business now?
You have one more rule on it.
If I can find my agenda. Not his favor, maybe. Under the new business, I think the item that we have noted there is electronic disclosure for rebuilt salvage vehicles. We recently, there was a rule that that was actually, it was brought up from the legislature, and the commission adopted language, and it dealt with the disclosure of rebuilt or salvage vehicles. It dealt with primarily the hard copy or the paper transactions. It did not address electronic transactions, and I think that is something that has been presented with some opportunities for improvement, to look at how those electronic transactions would be handled in the future. No language has been created for this particular matter at this time, because it's been presented for consideration for the first time to this committee.
Right, so what we were asking is that, the new rule for disclosures of rebuilt and salvaged vehicles recently became effective. So it is effective. That rule was looked at and drafted at the request of Representative Mike Sparks. We brought it to the commission, the idea of it, and the commission asked legal to assemble a team of persons to go and look at certain drafting language and bringing it back to the commission, and we did that, and that language was brought back to the commission. You all approved that language, and then it went into its effectiveness. During the pendency of when that rule was filed, the difference between when it was filed and when it became effective during that time period, our office was given notice that there were entities out there that would have to comply with this rule that had difficulty complying because our rule doesn't allow for electronic signature or electronic disclosure of that. One of those specific companies was Copar, and what they're essentially, they looked at it and said it's very difficult for us to comply with this because we don't have the ability to do electronic signature on the rule that we pass right now, and often, most of the times, our customers may not even be in the state of Tennessee, so we'd have to rely on a transporter to get a form back, physical form back to us. So we looked at that and we said, well, we may actually have dealerships that actually have the same type issues, a dealer that may want to actually require electronic signature for that. So there were some questions as whether or not there was going to be a protest of the rule actually done so that we could come back and look at it, and that was not done. There was not a protest. But in looking at the fact that there is potentially an issue out there about electronic signatures and electronic disclosures, I guess what we would ask is whether or not the commission would be willing for legal to go back to the original drafters of this and look and see if we couldn't create some language that would address electronic disclosures in general. In the previous group that you had it was legal. It was Bob Weaver was a part of that, and also Jim Cameron's office, and we would ask if we could have counsel or somebody designated from Copar to come back and look at drafting something like that, so that we could look at everybody within the industry and come up with some language that would kind of address electronic disclosures, and then bring that language back to this committee.
Motion made
Seconded.
by Lee, seconded by Murray.
Refer it back to legal for further and report back.
Right, with that committee, yeah.
Refer to legal for further review and report back to the committee. And roll call. Chairman Vaughn,
Yes.
Commissioner Lee,
Yes.
Commissioner Fox,
Yes.
Commissioner Murray,
Yes.
Commissioner White,
Yes.
Chairman Roberts.
Yes.
Motion carries.
Okay.
This is the RV dealer rule and fees that we approved last commission meeting. Just to update everybody that these have been posted with the Secretary of State, and they will be in effect in time for that new recreational vehicle statute act that's rolling out January 1. We didn't have to use the emergency rules, so that's nice. I don't think so.
No action needed.
Further business?
No further business. Maybe we do.
Hold that thought. Go ahead, Daryl.
Commissioner. Daryl Noble, Tennessee Independent Auto Dealer Association. Let's talk about RVs for a second. I've been talking to some of my RV dealers that are not registered to be RV dealers because they sell towables, which is not a motorized unit, and in the past they haven't had to have a license for that. They're looking at the application and going, it says franchise. There are no franchised RV dealers in Tennessee that are non-motorized. So they're looking at that and say, well, that doesn't apply to me. I'm not a franchise, because they can lose their dealership at any time. You know, the manufacturer doesn't give you a guarantee that, or that, you know, you're going to sell these vehicles and gives you a franchise like we do with a franchised new car store. I'm not sure how it is on motorized, but with Forest River and Thor, who are like General Motors and Ford, they don't sign any franchise agreements. It's all good faith. You sell stuff, we'll keep selling it to you. We won't put anybody in your backyard. You stop doing that, we'll put the next guy there. That's how it works. The other thing is line items. They were asking, okay, $400 for a line item. Is that for every line that I sell, or how does that work? I'm just wanting to be able to answer their questions. I don't know how the franchise dealers do it. I mean, if you're a, probably won't happen, but if you were a Ford and a Chevy dealer, is that two lines that you would sell? But if you're a Chevy dealer and you had if you're a GM dealer, if you're a GM dealer and you had in the old days Pontiac, Chevy, Buick, all of those, are those all different lines, or is it just one manufacturer? Okay, because with like Forest River and Thor, when they set you up to be an RV dealer, you're set up either, you know, with that one manufacturer, but they give you different lines that you can sell, you know, and because the lines are different than they are in the car business. If you're a Chevy dealer, you have all Chevrolets. If you are a Coachman dealer, for instance, you might sell the low-end Coachmans, and the guy down the street sells the high-end Coachmans, but yet you're only a Forest River dealer. Does that make sense? But again, there's no franchise agreements anywhere. That's just one thing to think about. The other thing to think about is, if we're going to handle this like we do the auto industry, well, let me just tell you where all the salesmen go that can't get licensed in the auto industry. They go to the RV industry. And we start telling those people that they can't sell RVs, we're going to load this place up for 2 days in appeals. So we have to handle that. I mean, there's probably a good 40 stores across the state that sell RVs that are not towables, that are not been registered, not counting the 28 that we do have, but other stores that are small mom and pop stores. And some of these mom and pop stores have been selling RVs for a long time, and some of them might have criminal records. Don't know that for sure, but I know the salespeople do, because when I make them aware that, oh, Johnny can't work for me, I go, well, yeah, it can. He's just got to go through this appeal thing. But, you know, we did 6 appeals this morning with 2 dealer appeals, and luckily the 2 dealers didn't show. So it made it a relatively quick day. Imagine if we had 15 of these people here, and that's what's going to happen if we start off. But
What is a line in the motor vehicle business?
what is a what?
In the RV business, what is a line? What is, I guess, what's that industry's definition of a line versus our definition of a line?
They just say, hey, are you a Forest River dealer or a Thor dealer? Okay, and you know, do you want to carry some? What products do you want to carry? They'll just give you a little bit of everything. As long as the guy who's carrying the mid-range stuff isn't next door to you, they'll give you the low-end stuff, and then they'll give another guy down the street the high-end stuff, and you can all be a Coachman dealer.
Well, I might compare that on the auto side to Toyota, Lexus. Each one is a line, and it's.
Yeah, but when you get
$4.
Toyota, you get everything that Toyota sells, and nobody comes in there next to it. And it's called Toyota, it's not called Lexus. So if you're
Right,
looking
but
at.
Lexus is a separate line.
Right, separate, Lexus is a separate
And
line,
you
so they don't
necessarily
have
get-
the same
You don't necessarily
name.
get Lexus with it.
They don't have the same name. But when you get Coachman, you can have 3 different lines of Coachman. You can actually have 4 different lines of Coachman.
What is a line of a Coachman?
Well, a line of a Coachman is you can be a low-end Coachman dealer where you sell pop-ups and then the cheaper campers, and then you can be the mid-range line where they're, you know, 35, 40,000, then you can be a
It's a Coachman
fifth wheel
product.
line.
It's a Coachman product.
It's a Coachman product,
Well,
and then
well,
you can be the
what is your-
motorhome line.
Okay, not to get too technical, but what does your MSO say? Does it say Coachman Industries or something?
It says Forest River, and then it's just got the description like the car. It'll say Forest River.
What is Forest River?
Forest River is the manufacturer. Okay, it's owned by Warren Buffett, Berkshire Hathaway Company. So there's basically 2 manufacturers in the country that are the big bosses. There's Thor, and then there's these. And what happened is when the industry crashed in 8 and 9 and 10, Warren Buffett came up and bought like 20 companies and just realigned them all under one parent company. And Thor did the same thing. They just bought Jayco, which was a multi-billion-dollar company, which was the last mom and pop
Does the
store.
statute say line or line make? Generally, when I hear
It
the
would
word
be in the-
line, make is associated with that.
I know, it's why it's just a little bit
I'm
different.
not sure this is line or line make.
I don't have the rule in front of me, but it will be however the motor vehicle one's currently worded.
My
Would it be under fees?
recommendation would be to change it to a manufacturer
I think it's under
and maybe take the word franchise off so we're not confusing anybody and add the word new. Okay? Because they don't have a franchise agreement. I mean, if this is the direction we're going in, and it looks like we are, and that's fine. If we say, okay, who's your manufacturer? Now, if you have 2 manufacturers, which you normally don't in the RV industry, and Thor's not going to give you Forest River products. They fight too much like that. So if you're a Forest River dealer, you could be open to 20 different products that they have, but you're still a Forest River dealer. But yet you're not a franchise dealer because they're not going to guarantee you anything. They're only going to guarantee that as long as you sell, we'll keep selling you product.
But I believe the statute requires for both motor vehicle dealers and recreational vehicle dealers that it's a condition precedent to getting either of those licenses to sell new, you have to have a franchise agreement. No, you don't. No, it isn't. It is in the statute. I mean, Ms. Shaw, that is an item that you check?
Well, a definition of a motor vehicle dealer, under the weight.
Motor
and this
vehicle
was-
dealer.
This was pre-existing before.
Motor vehicle
rules-
dealer, you have to have a franchise agreement.
So we're talking about the new recreational
And
dealer
the new recreational
statutes?
vehicle would require a franchise agreement if it's new and unused and a license to sell. And
Yeah, let me look at that then.
yeah,
Like we brought up a new topic.
No, I see, I think I understand your question now. You're talking about just recreational vehicles. Let me look.
you have to
I
look
mean,
at the definition of-
most boat dealers, and of course, we don't govern boats, they have no franchise agreement. It's, if you sell, we'll leave you alone. But I don't want dealers coming to me and going, hey, you know, I didn't sign up because it said franchise, I'm not a franchise. You know, they don't give you any signs, you pay for whatever you get. I mean, they don't even sell you signs. But the other concern too is my salespeople, so how does that happen, you know, when those guys can't sell? Quietest I think I've ever heard you guys in a long time.
I think it would be beneficial to us because I know it would be me from the administrative side, to have the questions clearly spelled out in writing so that we could review them according to what the existing statutes are and respond back, because it adds clarity to it for all of us, Daryl. For
I
us
just
to
wanna
be
be clear.
able to do that. So as I listen to the comments, I hear a number of different things that need to be addressed and researched in the rules and in the statute. So I think that is the most prudent way to approach this, which would help your membership.
As far as the rules go, I don't think we changed how RVs are treated at all in the rules. I mean, we literally just took all the current treatment and that they previously had under motor vehicles, then we just wrote "and recreational vehicles" beside it. So I mean, as far as, people shouldn't have been selling RVs beforehand if they had felonies, even before all this came into effect. So I'm not sure.
They were the non-motorized ones.
The non-motorized ones, that's what I'm talking
If
about.
they're non-motorized and have living quarters, they're described as recreational vehicle. And a licensed motor vehicle dealer under the previous definition of a motor vehicle dealer would have included recreational vehicle dealers as well. And we have a number of strictly franchised recreational vehicle dealers with all of the line makes spelled out at this point in time. And Mr. Noble's quite accurate. They're pretty lengthy as far as the numbers and types of recreational vehicles, and they are required to have a salesperson's license because they do fall under the Consumer Protection Act and the motor vehicle law. And the primary changes that passed through the legislature the last time had to do with the Franchise Act of the recreational vehicles. And so we're still getting familiar with a lot of it as well. But I think it would be beneficial for us all as we look at it to have your questions spelled out in writing so that we could address those thoroughly.
Does that work for you to
Yeah,
spell them out and
I just
send
don't
them
want to
to
clog up
Director
the
Shaw?
commission with a bunch of stuff, and we're not able to answer these questions for people, because that just doesn't get us anywhere. Simpler the better.
Just quick, currently, we are over motorized recreational vehicles.
No, we're currently over both.
Okay.
If they have living quarters. We are over let me give you a definition of a recreational vehicle. Recreational vehicle means a vehicular type unit primarily designed as temporary living quarters for recreation, camping, or travel use, which either has its own motive power or is drawn by another vehicle. The basic entities classified as recreational vehicles are camping trailers, travel trailers, and motor homes.
I think the other thing too is, correct me if I'm wrong, but it's, motorcycles and four-wheelers that are for use, not on the streets. Those would fall under that other category as well.
That's correct.
So if you've got a
At
motorcycle that's
one
beyond
point in
the tire,
time, a motor vehicle was defined as a motorized vehicle that's titled, self-propelled, and driven upon the roadway. Through the period of time, the recreational vehicles were brought under the umbrella of the Motor Vehicle Commission as well, and that would include the motorized, titled, self-propelled, and the non-motorized if they have living quarters in the unit.
Because when you become an RV dealer, you don't pay any franchise fees. You don't pay them any money to take their product line on. You just have to take it on. Not like buying a franchise store. And I don't know what franchise fees if you guys have to pay back. But I'm sure there's, but you had to pay something to get.
We do it other ways.
Yeah. Part
We
service.
have some expensive
Part
signs.
service. Let's put up a big sign. But you had to
We
buy
have
the
furniture.
franchise in the first place. So they got money on the front end,
Well,
and they keep selling.
Back to your question, and you might not know the answer to this, and I certainly don't, but in terms of what is a line or line make, will there not be a designation in the VIN number? In other words, if you're,
You cannot VIN code an RV.
I'm sorry?
There's one digit in there that tells you what the year is, but the rest of those numbers, it's not like a car where you could VIN code that thing and say, hey, it's a blue Impala with leather.
you know, because
Couldn't tell you
every
if it's
time
a-
I call to get a part, it's, give me the last
Well,
8.
there's nothing in the VIN number that would tell you it's, in a case, in an automobile, tell you if it's a Chevrolet. You'd have a certain couple of digits in there would say
It'll tell
Chevrolet,
you-
or a Jaguar would have a,
Yeah.
Toyota
yeah.
has a VIN, I mean, is there not one in the VIN number of an RV?
It's got a VIN number, but you can't VIN decode it. It doesn't tell you anything about it. Sometimes, I mean, they've had manufacturers use the same VIN except for the year models in them. You know, it's they're 20, 25 years behind the auto industry.
Okay, but when they start out, I mean, it started with a VIN number, are they all 17 digits like on automobiles?
17 digits now.
One of those digits would tell you whether it's a Craftsman or whatever.
Some companies did and some companies didn't. You remember, most of all these RV dealers up until probably 2010 were just mom and pop guys making these things in a building, you know, and I know that Forest River and Thor are wanting to get to that, to where they can say, hey, we're gonna put a VIN on here, we'll be able to VIN decode it, tell you your make, model, size, all of that, but they're not there yet.
Don't do
Now, I'm
just
sure
the line
I'm sure the big motorhome ones are, because
Yeah, the
they're already
motorhome.
coming with a VIN from Freightliner, Ford, GM, or wherever they're buying them, international, and then they have to cross.
And I think also the RV franchise agreement, as I'm sure Mr. Noble's aware, was bought by the recreational vehicle industry. So that would be a good resource as well.
You guys got some industry leaders and you're trying to work on some other stuff, I'll be glad to work on it with you. Okay? So, I didn't mean to put a bump in the road and keep us late.
Thank you.
Thank you for your time.
You have anything else?
Not on the agenda.
Excellent. We're adjourned.
Thank you.